Thank you. Welcome to the final day of the Inquiry and Advisory Committee for the Kentbruck Green Power Hub project. This hearing is being audio recorded and the recordings will be available on the Engage Victoria website. My name is Lisa Kendall and I'm Chair of the IAC considering this matter. I'm joined by Deputy Chair Member Michael Kirsch, Member Ken Joyner and Lachlan Wilkinson. I'm just going to check that the audio is working okay for those joining us online.
Oh, sorry.
I'll just ask for a thumbs up from somebody, or if you could pop your camera on and let me know. Excellent, thank you very much. Welcome to those joining us online. As you'll see, we're meeting in the Planning Panels Victoria Hearing Room 2 today, and we've also people are able to join and observe online. I'm going to run through the documents received. So we have received a number of documents over the last week. These have been added to the Engage Victoria website and the document share platform. We're working to document list number 70. I'll run through a number of the documents received. Thank you very much to the proponent for providing the documents in a timely fashion. It's very much appreciated by the committee. So we have received the final day, or what's also been called the Day 3 version of project documents for the Environmental Management Framework and the Incorporated Document, for the documents 482 and 483. We've received closing submissions from the proponent, which are with 5 attachments, so documents 485 to 490. We've received the response to submission summary table, which is document 491, the response to expert recommendations summary table 492, and the expert responses to the IAC questions that were detailed in document 450. And those 2 documents are document 493 and 494. And I will just cover off now the process. I will touch on this again at the end of the day, but as parties are aware, there is a process for parties to comment on the final day documents. So parties will have an opportunity to comment on both the Environmental Management Framework and the incorporated document in accordance with the IAC's original directions 38 and 39. So these comments will be due Thursday the 31st by 12 noon Thursday the 31st of July. And as I noted a moment ago, these are documents number 482 and 483. So parties can provide their comments in any form. You may use the documents and mark up comments, or you can provide comments in a separate document or email. And then the proponent will have an opportunity to provide final reply comments to these by Thursday, 12 noon Thursday, the 7th of August. I confirm that parties' comments on the final day project documents must relate to drafting only. And to assist everybody involved, I ask that parties please refrain from providing further submissions on merit of the project. And if further submissions on merit are provided with the comments on the final day documents, that information will be disregarded by the IAC. In terms of tabled documents, I'd just like to note for parties, and particularly those observing, or the parties who might be joining us online, as outlined in our privacy collection statement, all tabled document submissions and links to the recordings will be removed from the Engage Victoria website and the Google Drive document share platform after the IAC submits its report to the Minister. And we recommend that you download any of those documents that you require at this time in advance of that submission, and I'll talk further to the timeframes for our report later in the day. So before I hand to Mr. Kessel for closing submissions, I'll just ask if there are any preliminary matters that we need to cover. Welcome.
Not from us, thank you. Good morning.
Thank you. Good morning. And any other parties? And I'll just check for those joining us online. I'm just going to note we do have an email that one party is hoping to raise a preliminary matter, but is having issues joining us at the moment. So it's Ms Frances Thompson, who has a number of concerns that she wanted to raise in relation to matters. I understand she's having issues accessing. I will Ms Thompson, if you are able to hear me, given you're having issues with accessing, I'm happy to we'll keep the proceedings moving for now. And if you're able to join us before we break or after we break, I will come to you to mention those issues. But at this stage, we'll keep things moving. So it doesn't look as though anybody online is needing to raise any other concerns or questions or issues at this stage. So on that basis, I'll hand to you, Mr Chessel, and invite you to take us through the closing submission.
Okay, thank you. What I'd like to start by doing is just giving you an indication of how we plan to use the time today. We're going to break it into two main parts. The first thing we're going to do, like we did when we closed our case a number of weeks ago, is go straight to the Day 3 documents and walk you through the changes that have been made, both to the EMF and to the incorporated document. And what I hope is already apparent to the committee is the extent to which my client has sought to incorporate and give effect to the various recommendations that have been made in respect of those documents, principally by the authorities. The other parties haven't sought to engage with that material yet. But what we hope to demonstrate is that this is a proponent that has taken on board the feedback from the relevant authorities and sought to give effect to it, including by modifying the location, if you like, or the source of a number of obligations. That is, moving certain obligations from the EMF to the incorporated document, and by doing so strengthening those obligations, because unlike the EMF, which is a document to be prepared under secondary consent, the incorporated document to be amended would need be amended by formal process. And so one of the things that we'll be identifying is the extent to which the Day 3 documents strengthen various obligations that had previously been proposed to be given effect through the EMF. After we finish that exercise, what I propose to do is walk you through the written submissions. I won't read them out to you in full, but we'll touch upon what we consider to be the key aspects of the submissions. And we have sought to structure those submissions very much as a reply document, that is, to reply to the new matters that have been raised after the conclusion of our case a number of weeks ago. And that being the case, it's a document, or they're submissions that really need to be understood in the context of the other submissions that we've made, which will no doubt be apparent to the committee. Before we do those two things, though, I did just want to touch on a number of the other documents that have been filed. The first document is document 491. That is the updated response to submissions table. And we hope that that table will be of some assistance to the committee. We sought to set it out thematically, and in doing so, we've identified the relevant submissions, that is, on our review, which submission numbers concern the relevant theme. And furthermore, in setting out our client's response, one of the things we've sought to do is provide an updated and completed list of relevant reference documents. And we hope that that list in particular will be of assistance to the committee when you come to consider the various issues that you are charged to consider under your terms of reference. The next document, 492, is the updated expert recommendation summary table. And this is a document that was prepared in accordance with the directions issued by the committee at the outset of the proceeding. And again, what one sees is a tabulated record of the various recommendations made by the expert witnesses. And what one sees in the far right-hand column is the extent to which my client has sought to and has in fact given effect to the recommendations made by the independent experts engaged on its behalf. The next documents we wanted to reference, and we'll come back to these in passing in the submissions, is the further materials prepared by Mr Gibson and by Mr Organ. And if we focus first on document 493, we see Mr Gibson's response to the particular queries that were raised by the committee in respect of the Australasian bittern, queries arising from the presentation given by the Nature Glenelg Trust on the 8th of July. Mr Gibson's response addresses questions 2 and 3 on the basis that question 1 was really a question that arose in respect of comments made by Mr Organ. The corresponding document, document 494, is Mr Organ's response to those same questions. We note that Mr Organ includes a response to question 1 as well as to 2 and 3. So those two documents complement one another. Document 490 is a document prepared by Mr Gibson in respect of submissions made by the Nature Glenelg Trust, Bird Life South East South Australia and Mr Turk, and in particular those aspects of those submissions that raised what I'll describe as technical arguments or technical submissions in respect of particular aspects of biodiversity impacts. These being matters that weren't raised previously in submissions or put to Mr Gibson or Mr Venosta when they came to give evidence. You recall that Mr Venosta was unavailable to prepare a response for other reasons. Mr Organ has also prepared what I describe as a high-level response to some of those matters, and that high-level response is contained at the conclusion of document 494 and in particular from PDF pages really 11 and 12 onwards. We'll come back and make some reference to those documents in the reply submissions, but in essence, we will rely upon their contents as being a record of those witnesses' response to the technical matters that were raised, both by the committee in response to the Nature Glenelg Trust submission and to the extent that there are other issues that have been raised. They're thorough records of those witnesses' responses, and they speak for themselves. So we're happy to proceed on the basis that those documents will be taken as read, and I'll come back and make some observations about them later today, but we don't propose to read you through those. Okay, unless there's any queries from the committee or unless Ms Thompson has joined and wanted to raise her issues, we're happy to move then to the first part of our submission today, which really concerns the day 3 documents. And I'll be
confirm we may have some questions of clarification, but there's nothing that we wanted to put on the table at this stage.
Thank you. I should have also noted we're proceeding on the basis that we've now responded to the outstanding queries from the committee. I think that I did do an exercise this morning where I went through and sought to reconcile the lists that we'd previously had, and we think we've responded to the queries, but of course if there are any outstanding matters, let us know. And we'll
we've done the same, and we don't have any that we've identified either. Thank you.
Okay, thank you. Well, I'm going to hand to Mr Wright, who will walk you through the day 3 documents, documents 482 and 483. There's a tracked version and a clean version. I imagine you'd like us to be working off the tracked version.
And I should say that my computer has very inconveniently chosen this moment to stop working. So,
would you like a moment to sort that out?
No, I think it's an unresolvable problem, but thankfully I printed out the documents. So what I might have to ask is Ms Harwood if she could share document 482 and the tracked version on screen so people can follow along. I'm now very grateful that I printed the documents yesterday. Hopefully I can resolve the problem later today, but not now.
Note as well, as people are aware, there are some heating issues in the hearing room, and we understand we've got some small heaters. Please feel free to do what you need to stay comfortable. If they need to go on or off, please do what you need to do.
Within some limits.
Check with member Kerr.
All right. So what I'd like to just say first is just to explain the approach that we've taken. Mr Chesil's explained that in a bit of detail, but we were grateful to receive the documents, and I'm going to start with the Environmental Management Framework. We were grateful to receive the marked up documents from DCA and Parks Victoria in particular, as well as the Council and the CFA comments. Now, by and large, with some exceptions, we've adopted the Parks Victoria changes, and we've adopted the changes by the CFA and from Council, and I'll take you through those as we go. We've largely aligned with the DCA changes, except with a couple of particular issues that you would have seen highlighted in the written submissions. And more form over substance change, which is where we haven't pulled something across into the incorporated document. Mostly we have, but I'll take you through the documents to explain where we haven't adopted a change that's been suggested and why. But we've really critically analysed all of the changes that have been proposed by those parties, and where we could, we've adopted it. Where we thought the language needed to be adjusted, we've made those adjustments, and I'll take you to those as well. But we've really started from the premise of where the change was, we thought sensible, we've adopted the change. Now, we've sought to apply a consistent colour theme across the two documents, and you'll see it's really the green and the pink changes that have been highlighted, which are the further changes. And pink is responding to a submission change, pink or purple, depending on what you can see on your screen. And green is a further change that we have made, either unrelated to a submitter request or adjustment to a submitter request. So you can see throughout the document it's green and purple, and they're interspersed with each other. What I'd like to do is start with the EMF, if I can, so that's document 482, and then I'll come to the incorporated document. Why I'd like to do that is because you'll see that we've pulled a few things across into the incorporated document, and it's more convenient to describe those later by reference to what we've kept in the EMF by contrast to what Dick has asked for. So if I can take you to, well, I won't, Madam Chair, I won't take you to the minor typographical editorial. There's quite a few greens that we've corrected clause, for example. I'm not going to bother with those. I'll take you to the substantive changes. The first one I'd like to take you to is, and what we've proposed is new BS01, so you can see in green on screen. And I should explain. So this drafting was suggested by DECA in its version of the EMF. It had asked for that to come across into the incorporated document, but the thematic approach we have taken is to bring across those parts into the incorporated document that require effectively the higher level control plan, so the BAMP and the Barolga compensation and monitoring plan and offset requirements, including in respect of species or native vegetation, and put those in the incorporated document. But where it's a more, if you like, operational construction type plan, we think it's better placed for consistency in the EMF itself, which is why we've retained what we've called new BS01 in the EMF, which relates to construction activities on Boiler Swamp Road. So that's the thematic difference that we've taken from the DECA approach, and I should just pause and explain why. The incorporated document that had been proposed originally is really a major projects type incorporated document where you don't have the minutiae of the controls in the document itself. You put them in the EMF. The alternative is to do it in a more permit style incorporated document, and the example of Golden Plains that we've given you is one of those type incorporated documents where most of the work or a lot of the heavy lifting is done in the permit type control itself. But because we've adopted the major projects approach, which Mr. Glossop supported, I've sought to maintain the minutiae in the EMF as opposed to the incorporated document for ease and for clarity. Right. So, new BS01, it is, as I've said, largely the drafting that was suggested by DECA, and we think it's appropriate to have that in the EMF. But if we go over the page to the final two dot points, and I might ask Ms. Hull if you can zoom in the screen a bit, and that relates to how and when really emergency access would be allowed across Boiler Swamp Road during fire danger periods and for emergency management purposes. The point of distinction here is that the DECA drafting identified particular times and said must maintain through those periods, but we've adjusted the drafting to require the plan to show how emergency access will be maintained as opposed to mandating access through particular times. And it's convenient for me to explain why we've taken that approach now, and you will have seen this in the written submissions, but fundamentally it's because it's not going to be every January and February period when we can't construct along Boiler Swamp Road. It'll be dependent on the situations at the time and whether bushfire conditions are in place that would propagate or allow bushfire to propagate, which would necessitate access. So you might have a colder, wetter January, February period where there's no fire risks, and so in our position, you shouldn't then prevent construction activities occurring. Rather, the process should be that you need to provide a process whereby emergency access can be provided in the circumstance where it's necessary to do so. And we've said in our written submissions that the conditions that allow bushfires to propagate don't come out of nowhere. They develop over a long period of time. They're well known in advance. And so what we think is appropriate is that there be a process that the CFA and DECA would have to sign off on so that they can be confident that emergency access will be allowed or available if it's necessary to do so. So we don't think there's a fundamental difference in approach, but we think it's better to be facilitative rather than prohibitive in respect of when construction can occur. We've sought to draft for that facilitative approach. If we scroll down to BD01.
One question for you on that. Actually, I don't have a lot of questions in advance of you giving us the verbal submissions today, but I did have a question about that, and it may be a moot point, but I know so that new mitigation measures called Construction Environmental Management Plan, the focus that you've just been talking us through relates to the emergency management. I do note that it's proposed to be prepared in the satisfaction of DECA regions and bushfire forest services.
Yes.
So it's got the dual focus of emergency management and land management activities. There is a last dot point. So there is, again, it touches on the need to facilitate emergency management and land management activities. But the final dot point also does provide reference just to DECA bushfire services or forest services in relation to emergency management and land management priorities. And I was wondering whether there are other entities or agencies that need to have access for land management purposes, not so much the bushfire, and whether that's adequately captured or just, and I'm not, you can comment on that now, I'll come back to it if you like.
The comment that I'd make is we have not adjusted that part of the drafting, so that was DECA's suggestion. So to the extent that DECA says, DECA, as I understand, is listening in this morning, and we haven't had an opportunity to speak to DECA about this drafting between their version and this version, but no doubt if they think there's another arm of DECA that needs to be referenced, then they can raise it. So we haven't adjusted that part.
No, no problem. Thank you very much.
All right. I don't think I need to take you to BD01. We've largely adopted the drafting change to the chapeau that was suggested by DECA. We'll just go down to BD02. You can see that we've deleted that. That's been moved into the incorporated document, the offset requirements. I'll come back to that when I come to the incorporated document. The next one down, which is, I don't know, the BD02 now, but if we go, this is about tree health along Border Swamp Road. If we go down to the next part, you can see the pink, purple and the green there. This is related to the reconciliation. So you will recall that it's been contemplated, including in accordance with the relevant standard, that if it turns out that fewer trees are lost than had been anticipated, we can do a reconciliation. So this is where that's allowed for. We've adopted the DECA drafting, except that the DECA drafting had said that that reconciliation should occur at the completion of the project, which would be in 30 years' time. Now, we think that's too late because, amongst other reasons, it would be very difficult, if not impossible, to know what has been lost as a consequence of the project, as opposed to 30 years of natural attrition after that period of time. So what's required, if we were just to go up the page a bit, Ms. Harwood, you can see that the third dot point is a further post-construction survey between 24 and 30 months following completion of construction. We think that's the trigger point at which the reconciliation would occur. You would ordinarily know by then what the impacts on the trees have been as a consequence of construction. And so you'll get the before and after picture at that point. And so the change we've made over the page is to have that the point at which reconciliation would be triggered. So when that survey starts, that's the point of distinction. If we could move down to BD06, the Border Swamp Assessment of Losses.
I need to get people to check their computers are mute.
Try again. Okay. No, not quite there yet.
Must be someone in the room, mustn't it?
Will be.
Is it-
Blue phone, but it's on mute now.
Oh, I see.
Okay, great. All right, so you can see again the pink and the green changes. The first one is not material. The only material change we've made is in point 5, and the DECA drafting had earlier drafting had suggested that the results, that confirmation no Applejacks would be impacted, and what you can't see in the highlighting is there's been a change to that particular part to introduce will, but the green has been added to make a reference back to the Australian standard, which is where you know what impacted means. And so we just thought it was important to introduce that link for clarity for that purpose. Now, over the page, there's some green that you'll see. There's been a deletion. And what we've done there in the added green text is to take a link back from this mitigation measure, which is specific to losses along Boiler Swamp Road, back to BT01, which is where you find the requirement for a native vegetation plan, which is the overall project assessment for vegetation losses. So we thought it was necessary to have that link back to make sure that the NVP under BD01 has to take account of this report that's specific to Boiler Swamp Road. The purple change that you can see there is a DECA change, which is to require HDD to be undertaken at a depth of 750 millimetres as opposed to what was the 600 proposed by us in accordance with the Australian standard. And that's, you'll recall, that's the deep ripping activity that DECA says may need to occur to make everything below that point. Very briefly, if we can go down to BD10, we've just added in the second paragraph the reference to the words "but excluding works for the main substation," which is reflective of the same words in para 1, and that responds to, I think it was Member Wilkinson who raised a question about that, so we've just made those consistent. Now, over the page, in the pink or purple, that's the offset requirement for the Australasian bittern, which DECA requested to move out to the incorporated document. So we've done that. The paragraph under that, so there's a couple of green there where we say monitoring technologies such as, and we've added after GPS satellite camera-based tracking of movements, just to be a bit more flexible about the types of technology that might be used for that monitoring purpose. The next major change is to take the BAMF requirements out of this document and put them into the incorporated document. So I'll come back to that. I won't take you to the pink insertions into BD11 and BD12. And then if we scroll down to BD15, this is the Ecology Fund, just back up the top of that page. Again, that was requested to be moved into the incorporated document, which we've accepted, so I'll come back to that. Same for the Brolga Monitoring and Compensation Plan, further down the document, which has also been moved out to the incorporated document. And then, if we could please go to page 19 of 30, SW09. All right, there, Member Kendall, this is to address your comment or question from the other week about use of the word consider in mitigation measures. I undertook a very careful review of the document to find out where that was used, and you'll see that we've adjusted some, but not all of the use of that word or consider or consideration, and there was a logic to it. But we're also not suggesting that we are the best drafters in the world in that regard, and you might find some other words that where it's used consider that you think a more directive approach is required. But what we've done is review the document thoroughly to identify those instances, and where we thought it was appropriate to be more specific or directive, we've made the change, but where we thought that the use of the word was appropriate, we've retained it. So I won't take you to the other instances where that's occurred. If we could then go down to page, 44 of 19, backwards numbers, LV01. All right, so we've really, other than one change, adopted the Parks Victoria suggested approach, which was to delete the reference to the Great South West Walk Committee. And you'll recall that Mr. Tobin described Parks Victoria's approach is to always consult with the relevant stakeholders. And we understand that the two key stakeholders in that sense here are the Walk Committee and the Conditioning. And so we've just simply adopted that change. Now, I recall, I think that was Member Kendall or Member Kirsch had raised a question to Mr. Tobin about whether, I think it was you, Ms. Kendall, about whether it was appropriate to make that deletion. We've adopted the approach that Parks Victoria takes, given that they're the ones who would really be undertaking that consultation. But if you thought it was appropriate to make a specific reference, then I don't think we would resist that. That, of course, was in the original drafting, that specific reference to the committee. And there's a later reference to the Gunditjmering as part of consultation on this generally, which we've left alone. So we're really happy to leave that to the committee to accept or make that change as it sees fit. The next part is to, as I said, we've adopted the Parks Vic insertions in relation to investigation for jetty facilities and or environmental programs. What we hadn't adopted, the very final part of that was a maintenance plan requirement, which Parks Victoria had sought to be for a period of 10 years. You will recall that the evidence of Mr. Hark about that duration was that ordinarily it would be 3 years. And so we've made the change to be 3 years, not 10 years. Now, that's a point of difference between us and Parks Victoria, but we rely on the evidence as to the basis for that change. Now, over the page, LV06 about shadow flicker assessment. This is in response to a query raised by you, Member Kendall. We've substantially changed the drafting. On reflection, we think you were very right to observe that the drafting was a bit unclear as to what was intended and for what purpose. What we've understood the intent to be, and this is what we've drafted for, is that, and there's a few elements to explain in this, that any existing dwellings at the time that the technical appendix assessment was done, and I'll come back to that in a moment, there can't be any further exceedances of the 30-hour metric that comes from the wind energy facility guidelines unless there's an agreement reached with the relevant landowner. So we've drafted for that outcome. So you can only exceed the 30 hours if you get an agreement. Now, the elements to discuss are the timing point. And so why we've said that it's existing dwellings at the time that technical appendix M was prepared relates to VC 212, which we've discussed earlier in the hearing. And the consequence of the introduction of VC 212, which predated the technical appendix assessment, was to, and this is my shorthand, is to shift the onus to new permit applicants for accommodation within 1 kilometre of the boundary of the wind energy facility, inclusive of this one. Because we are in the EES process, that's one of the bases on which the onus shifts under the new or extant controls in the scheme. So any dwellings that post-dated that change had to have taken account of the potential existence of this facility specifically. And so they would have had to have demonstrated to the council's satisfaction or the responsible authorities' satisfaction that the location of that accommodation was adequate, assuming that the existence of this facility. And so that's why we say that the trigger point is only existing dwellings at the time that that assessment was undertaken. Now, there are only two, could only ever be two under that scenario, and there are agreements in place for both of those landowners. That's its residents 21 and 675. So we've just tightened the language to be clearer. That's the first point. The second point was about where the metric or what work the guidelines have to play in this assessment. The only work they have to play is that's where you find the 30-hour metric. So there's not a necessary requirement that it be in accordance with the guidelines, because there's nothing to be in accordance with other than the 30-hour metric. So we think the drafting now properly reflects the intention. Over 2 pages, if we go to page 50, please, Ms. Harwood. At the bottom of that page, you'll see some green. Now, if we just pause there, there's 2 things to say here, actually. Oh, no, I won't take you to the pink. The pink was a change from Parks Victoria, which we think was acceptable to make. But the green. So this, again, to the committee's questions about how the independent environmental auditor has been described in the document. So we've undertaken a thorough review of that concept, and there are 2 concepts. The one is properly the IEA, and then that's one role, if you like, and I'll come back to that. And the second role is the auditor responsible for signing off on matters that relate to noise or acoustic matters, and that's where the auditor would be a separate auditor, if you like. There's a regime that exists under the Environment Protection Act, and the auditor is appointed and accredited under that act and regime. And so we've been sought to be clear about the distinction between what's the IEA proper and what's the environmental audit for purposes of noise matters. So we've just clarified the drafting there for that purpose, to refer to a particular part of the EP Act and to separate those 2 concepts out. And there's some other changes that you'll see in the noise and vibration section that reflect this green drafting on screen. So there should be consistency now between all of those. And as I said, I'll come back to the IEA proper. So I won't take you to NVO 5 or NVO 6 because the same change has been made to those. I don't need to take you to NVO 7, which is a Parks Victoria change, or NVO 9. I'll just briefly take you to TPO 2 on page 55, please. Might have just gone past it. Yes, right there. So you can see in the middle of that, there's a purple word that's highlighted, authorities. It used to say authority, and this was a point that was raised by the council. I think that the term used in the council drafting was, the council comment was co-authorisation or co-endorsement. It seemed to us that there may be a situation where there's part of the first TMP, if you like, the one that's directed to the road network more generally, might touch council roads and DTP roads, in which case we just made the change to authorities. That was the word that was suggested by council, so we accepted that. Over the page, now we're at the top of page 56, please. And there's no change. Next page up, please, Ms. Harwood. Yes, right there. So I'm pausing there. You'll see in your version of the document there's a comment where we've indicated that council had requested a change, which was to, in the second dot point, require that the review of existing conditions of public roads occur before the development starts. And we've I'll just explain why we haven't adopted that change. It's of no consequence really, but what it currently requires is that the review of the public roads occur at the time of the traffic management plan being developed, which we think is the right time because, of course, that's when you would be looking at these things, which in any event is before the development starts. But we thought the timing was quite important. So to tie it back to the TMP itself, we just left the drafting alone. We thought that was a better outcome than the change suggested by council. There's another, if we go 2 pages down, please, to page 58. You won't see anything in the drafting, but it was on this page, there was another suggestion by council to include an additional point regarding engineering review and acceptance report for any traffic upgrade works to be provided and signed off by the authorities. I'll just explain why we haven't made that change, and I'll need to do so by reference to the page earlier. In the middle of that page up, there's a dot point that starts design drawings. What we'd understood, the intention was that there be really the design drawings provided for all of the roadworks and signed off. And so we thought that was already covered, which is why we didn't make the change. If we go to TPO 3, please, which is on page 60. This was a council suggested change. The final dot point that they had requested that there be. The council drafting was on completion of roadworks prior to use commencement, that there be another road safety audit done. We were just concerned to disconnect commencement or operation of the use from completion of roadworks, because things might occur in a staged manner. There might be roadworks undertaken one part to get turbines up and running, and those might commence while roadworks are occurring further up the turbine field, for example. And so we've just required that the audit be done within 6 months after the completion of roadworks, and just remove any link between that and commencement of the use because of that stage issue. Very briefly, going to SEO1. You'll see that if we can scroll down the page a bit, thanks, so in the green that we've added in. And this is the same changes being made to SEO1, SEO2 and SEO3 for those 3 strategies that they be prepared in consultation with the council. Now, you might recall the council's oral submissions raised a need or a desire for these plans them to be involved in the preparation of those plans. That change didn't translate into any drafting change that was suggested in the document filed by the council, but we thought it was sensible to make that change in any event, so that we've introduced that consultation obligation for those 3 plans. You will have seen in the written submissions that Mr. Chessel may come to that we had rejected a suggestion that council be involved in the administration of various of the offset or the community strategies. We think it's appropriate for the strategies to be prepared in consultation with the council, but not for them to have any oversight in the operation of the strategies. If I could take you to the bushfire mitigation measures, BFO 1 and so on. What we've done in those, if we can scroll down the page, where there's a pink change, it's been a change made as requested by the CFA. I won't take you to those in any detail. What I'd like to take you to is BFO 4. You can see the dot point with green on it, which is about lightning conductors. There's a slight difference between the CFA position and our client's position in respect of, I can't remember the precise wording that the CFA proposed, but that was really to install lightning strike detection systems, and clients' understanding of those systems is that they're not always effective in operation. But so it doesn't want an obligation to install a system that really, where there's a lightning strike, it always turns the system off, etc. But it's happy to have an obligation to assess the suitability of those type detection systems. Now, there is a requirement already for lightning conductors for all turbines, but it's really that the next step of turning everything off. You may not need to, and they don't always work well as we understand it, but we're happy to have that obligation, sort of the halfway house towards the CFA position, which is to have the suitability of those systems assessed. I don't need to take you to the next few changes. If we can go to BFO 6, yes, the top of that page. Remember, Kirsch, I think it was in response to a question that you'd raised, that the fire management plan be developed in consultation with the CFA. Those words have been inserted in the chapeau. And then the first dot point, this is a point of slight distinction between the DECA suggested drafting and our drafting, which goes to the comment I've made earlier in respect of our new BSO1, which is about making sure there's a process for how emergency access will be provided during critical danger fire danger periods, as opposed to mandating access, if you like. So I think it's just about the process rather than the outcome, but the outcome's the same. And then I think the final matter I wanted to take you to was the final mitigation measure, second to last, which is about the independent environmental auditor. So, as I've said, we've sought to be very clear about the distinction between the two types of auditor. And what we've added into IAO1, we've adapted from the Environmental Management Framework for the SRL East project. And it's in particular, it's EMF 3 in the equivalent version of this document for the SRL project. And we've adapted it. We haven't brought it across in totality, but we've adapted it to what we thought was the right drafting for this circumstance. And it requires review of the relevant 3 plans and at the relevant time periods and in accordance with what otherwise is required by the EMF, just to expand and clarify that role and what the expertise will be. And it really is, I think, as anticipated by you, Member Kendall, it would be not one person, but it's a persons with their relevant expertise. It might be more than one person. So we think now that's been clarified throughout the document is how that's intended to operate. One thing I'll note here, which I'll come to when I come to the incorporated document, is that what you won't find in this mitigation measure is reference to the BAMP, and that's intentional because we've included in the incorporated document drafting for the BAMP the audit requirement there. Same person or the same entity, but just for consistency, we've put it in that document. Right, the final matter, please, just to briefly take you to, is on page 86, which is the list of key documents. And we've just added in defined terms for the BAMP and the BMCP, the Brolga Monitoring Compensation Plan, which now both live in the incorporated document, but because various of the mitigation measures in the EMF still refer to those 2 documents, we just wanted to make sure that the link where you knew what they are is added to that table. I think the very final point, just scroll down the page, we've just deleted the references to those plans from the list of plans and strategies that we've previously included at that table. All right, that was everything for the EMF, Madam Chair. If there weren't any questions.
I'll just check with the members if there are any questions. All good. I have one question, just a clarification, and just find the right one, which relates to the turbine that's referred to in the groundwater mitigation measure GWO5. He hasn't spoken to this, but it was just my reading of it. I wanted to be 100% sure if there's a reference to a turbine that it's one of the matches the turbine numbers that the IAC will be working with.
Yeah, stretching me at the
GWO5, and my understanding it refers to TP05.
Madam Chair, can I trouble you for a page number? GW. I know I found it. Thank you.
The GW05, I'm happy for you to come back to us on that. And we've extracted from the area of TP05.
Yeah.
And I just wanted to be 100% sure that that reference matched the turbine number reference to the document.
I don't know, but I'll find out.
Thank you. We'll just ask as well, in terms of groundwater, there's a couple of references to the agency, the catchment management area. I'm going to assume that is the catchment management authority. And obviously to make that recommendation as a change, but I didn't want to assume that just in case. I'll just mention that as well. So that was GWO6 and GDO1.
The GWO6, this is the final sentence, the final line, Madam Chair?
Yes.
Yes, that would seem to me to be the Catchment Management Authority.
Yeah.
I might just confirm that.
2 references. There was that one and then the GDO1 as well. So that's yes. So just to confirm. Seemed obvious that's what it was.
It's a safe assumption, but we'll confirm.
Thank you. No further questions from the committee.
Thank you. All right, so if we could, Ms. Hubbard, please go to document 483, the incorporated document. And similarly, I won't take you to minor points, but if we could go to the native vegetation clause, please. This should be on page 7, starting on page 7. All right, so the approach that DECA had taken was to put in, if you like, the maximum that could be removed, and then to specify the offset requirements by reference to the documentation in the EES in the condition itself, or the clause itself, and then set out the particular offset requirements, by which I mean the numbers that are required to be offset, and then evidence and the like. Now, we don't think that's the right approach. We think the better approach is to really adopt a hybrid between what we had originally proposed and what Golden Plains, the incorporated document for Golden Plains, did. And we provided you a copy of that document, which is in our 7.14 specify the maximum that can be removed by reference to the assessment that's been done in the EES. So that's the 8.696 hectares. But then require, which is in 7.15, the native vegetation plan to be prepared in consultation with DECA and submitted and endorsed by the Minister, at which point it then becomes part of the incorporated document. And then you'll see this, the last sentence there is, the NVP must include or address all matters relating to native vegetation removal required by the EMF that's approved pursuant to clause 7.8. Now, that is to capture that what is really BDO1 in the EMF, which is where you find what's required for the native vegetation plan, the detail of that plan, which will be full survey of everything and then identifying what's going to be lost. The reason we think that's the better way to do it is because, as you've heard from us and from the experts, that it's likely that the estimate is going to, of what will actually be lost will be lower than what's been assumed for purposes of the EES, which means that the offset requirements are likely to be lower or different, at least, from what's been assumed for purposes of the EES. Now, if we hardwire a particular offset requirement in the incorporated document, then we can't do anything different unless you amend the incorporated document, or otherwise there's a reconciliation of the requirement in the document. But we think that's a bit messy and unnecessary, where what you can do is refer it off to the EMF, which is required to do any NVP, you work out your offsets, and then in the EMF mitigation measures, you then have to prepare an updated biodiversity assessment and updated native vegetation removal report as part of that process of the native vegetation plan, which will ultimately determine the offset requirement. There's an obligation to do it that sits in the EMF through this document. So no steps are missed, but we think it's better to do it in the EMF through that process rather than hardwiring a particular outcome in the incorporated document. And that's effectively what Golden Plains required, except there was more detail in that document as to how you prepare the plans and the like. But we think because it's already in the EMF here, that it should stay in the EMF. And then otherwise, 7.17 is evidence of offset and security agreements, etc., and 7.18. So there's no, I don't think, any real dispute between DECA and ourselves about those two. It's really what you need to do by way of offsetting. And we think our approach is the better approach. One thing that you might observe, I'll just raise it here, in the Golden Plains incorporated document, is that there's a clause there that allows the proponent to go through a reconciliation approach. Because that's already addressed in the EMF, I didn't bring that across into this document because it's already been addressed. So that's really the conceptual change, or conceptual difference rather, between DECA and ourselves, but we think the outcome we've drafted for is a superior outcome. Okay, if we can then go to the bird and bat adaptive management plan. It looks like there's quite a lot of changes, but there's not really. The chapeau, to 7.19, the changes are really just minor changes for consistency. What I'd like to take you to is 7.20. The new B is just to provide a direct link to anything required by the approved mitigation measures in the EMF, because, as I said earlier, there's elements in those mitigation measures that refer to BAMP requirements that we think need to come across into this document. So we just made that link. And then really it's D, E and F, which was the drafting primarily that was suggested by DECA. So F, this is the presumptive use of advanced technology. Sorry, D. So the presumptive use of the advanced technology for monitoring purposes, and we've accepted that concept. Made some minor changes to the drafting, which I don't think are of consequence, but this concept of a camera identification systems or a suitable alternative. E is where I'd like to focus some attention. So what E requires on the DECA approach is to adopt the use of that technology for operational reasons, provided, unless, I should say, demonstrated to the satisfaction of the minister that you don't need to. That's the concept. And so we didn't quite think that the concept from DECA was properly reflected in the drafting, and this includes, you may recall Mr. Tobin's closing submissions that referred to this issue when he described the concept, which was that you might use advanced systems, camera technology, whatever it might be, unless alternative measures are demonstrated to be suitable, or he then said, or no measures are required, if that's what the monitoring shows. So the concept is you do the pre-commencement monitoring on a presumptive basis. If that monitoring shows you need to do more or do something similar during operation, then you have to do that. But equally, if it shows that either some other system can be effective or you don't need to do anything else, that's now captured properly by the drafting in D. We don't understand that to be any point of distinction between us and DECA about the intent for that. But as I said, we haven't had a chance to speak to DECA about that. But what I've tried to do is reflect what was described by Mr. Tobin in his oral submissions about this clause. Then if we've made no changes here, that really was existing drafting that has been only minorly changed. Over the page, you can see there's a section highlighted in green, a number of dot points there. All I need to say about that is in the DECA document, they put these three in all of that green drafting in strike through, but hadn't highlighted it, and it wasn't clear to us why they deleted it, and it seemed sensible for us to retain that. So we've just reinstated it. We don't understand why DECA had proposed that change. It might have been an error, I'm not sure. Over the page to 7.21, we've just made a minor change to the DECA suggested drafting, which was about within 2 months of the completion of each 12 months. And we just said each 12-month period during operation, the operator must submit raw data and monitoring reports to the minister and make it available, make the monitoring report available on the website. So just largely accepting with some drafting clarifications what DECA had suggested. And then 7.22 is where we've addressed the audit requirements for the BAMP, which are slightly different from the audit requirements for other documents in the EMF mitigation measure. Really, there's a distinction between the construction and operation. So the EMF mitigation measure requires reports for construction times as well, which is not relevant to the BAMP. So we've just hardwired the specific review requirements and reporting requirements in the BAMP drafting and the incorporated document. 6 months, within 6 months of full commissioning, and every 2 years thereafter, review and then make recommendations and report to the Minister and DECA. And so that component is the same as what's in the mitigation measure, but targeted to what would be necessary for the BAMP. Then I think really the final point, almost final point, a couple more, in the Brolga Monitoring Compensation Plan clause, which is over the page, the only point of distinction here, other than where we've just made some more clarifications in the drafting, is whether the population viability analysis that's in the EES documentation is what you use to, for purposes of the MCP. That's what DECA's drafting suggested. We don't think that's appropriate, and I'll explain why. So the population viability analysis relies on, and we haven't explained this very well in our comment, but I'll explain it to you now. The PVA relies on the collision risk modelling. The collision risk modelling relies on a turbine layout. The turbine layout will change, and so the collision risk modelling has to change, has to be redone. And consequently, the PVA should be redone. The outcomes might be different. And specifically, the number of juveniles that would have to be replaced as a consequence of the assumed losses and mortalities from the operation of the wind farm. So I'm not sure if DECA had properly comprehended the link between those three steps. And so we've sought to just be clearer that you have to redo the PVA, which should then inform the ultimate monitoring and compensation plan because the turbine layout will change. That's the only real point of difference there. I don't need to take you over the page to the Australasian return offset plan other than to note that that's been pulled across, some adjustments to the language, necessary adjustments. And then ecology fund, just briefly, the next one over, the last comment. DECA had suggested really a fundamental rewrite to the ecology fund requirement that was in the mitigation measure. Not to a substantive end change, but just more detail about how and what it's directed to, which we thought was sensible. So we've adopted the DECA drafting with some minor tweaks for clarity, and the only really substantive change, or addition rather, it's not a change, is the final part, where we've added reference to not only the bent wing bat recovery plan and conservation advice, but any equivalent plans or advices that apply to other species, because of course the claim is not only directed to the bat. And that was it.
No questions, thank you.
Thank you. Just before we move off this exercise, the committee raised a query about the reference to TP05 in mitigation measure GW05. And the reference to TP05 is a reference to a test pit number and location. That location is shown on figure 2A of Appendix I to the EES, and that's on PDF page 68 of that document. And it may be appropriate, and we can address this if the committee would like, for the reference to TP05 to include a reference to that plan, yes, so that one can reconcile exactly what that is a reference to. We will come back and confirm, but we are confident that the reference to the relevant catchment management area should be a reference to the relevant authority.
Thank you.
We'll confirm that after the break.
Great, thank you very much.
Okay, what I'd like to do now is turn to the reply submissions, and I'm assuming the committee would like to continue up until a break. I know that you mentioned you might seek to fit in whether there was a preliminary matter that wished to be raised. If you're not sure whether that's submitted online now and whether you'd like to do that now.
Maybe. I'm happy for us to go through till 11:25, let's say, and then I'll ask the party to raise their issues, and then we'll break for 15 minutes after that. Thank you.
Okay, thank you. Can I please ask if the committee has the reply submissions before them?
Yes, thank you.
You'll see at paragraph 1 that we note that since we closed our case on the 26th of June, there have been, by my count, at least 39 submissions that have been made before this committee. And what we explain at paragraphs 1 and 2 is that we've sought to frame these written submissions as a true reply and that they should be read in conjunction with the other materials that have been filed with the committee. At paragraph 3, we have explained the way that we've structured the reply submissions, and we'll talk to that structure or work within that structure today. We'll start by addressing you on the submissions made by the relevant statutory authorities, which include DECA. We'll then turn to the submissions that were made by either environmental organisations or by individuals, and that can be distinguished on the basis that they sought to advance submissions that were really in the nature of expert evidence or technical matters concerning ecological impacts, and we address those in Part C. We then go on to address that group of submitters that focused very much on the scientific basis upon which the Brolga impact assessment was conducted. And we then address the balance of the submissions, which of course raised a wide range of issues. The other two things that we've done in this reply submission is, in Part F, respond to the query raised by the committee in respect of the panel report prepared for the Portland Wind Energy Project. And we've included a concluding section that addresses the terms of reference that the committee is charged to respond to. What I'd like to do is start by working through the introductory sections that we've prepared in respect of the DECA submission, the first of the relevant statutory agencies and authorities that we respond to. And we start by making the observation that it is readily apparent, and no doubt apparent to the committee, that a key, if not the key, issue that arises for consideration in respect of this project is the potential ecological impacts that arise. And in that respect, we note that it is relevant that DECA is the peak state agency responsible for management of biodiversity in Victoria. At paragraph 7, we make the observation that unlike a number of other submitters that raise concerns in respect of the ecological impact of this project, DECA actively participated in the hearing. It did so by testing witnesses under cross-examination. It reviewed the documents that were filed by the proponent, and it engaged directly with the relevant EMF and BAMP provisions. And furthermore, DECA played an active role throughout the TRG process, a process that was particularly lengthy in respect of this project. And pausing there, members of the committee, we make that observation because in our submission it is significant that DECA not only possesses the statutory responsibility in respect of managing biodiversity within the state, but furthermore that in discharging that statutory responsibility here, it engaged directly in the materials that are before you. And we'll come to submissions made by others in due course, and we're certainly mindful of the challenges posed to members of the public in participating in a lengthy hearing like this. But we do say that it is significant that this authority engaged in the process conducted over the past 8 weeks and in the material that was filed before you. And in our submission, some of the other positions that were put before you, including by the Trust and other submitters, suffered from not having the benefit of engaging in not just the material that was filed with the committee, but hearing the expert evidence that was called. And there were some submissions made by others about concerns raised about the capacity or qualifications of the witnesses that were called. And those types of submissions in our submission should not be given any weight in circumstances where the party making that submission did not engage, did not attend the hearing during that part of the process where that evidence was called and tested. And so we say the fact that DECA did do that is of consequence to the weight that one should give to the position expressed by the department. And so at paragraph 8, we note that it is significant in our submission that DECA does not contend that the project would give rise to unacceptable risk to the ecological values of the site or its surrounds. Instead, on a fair reading of the DECA submission, what DECA did was to identify certain matters that it says warrants ongoing investigation, but to go on to make explicitly clear that it considers that those matters can all appropriately be addressed through mitigation to be implemented by way of the EMF and, I suppose now, also by way of the incorporated document. And so while my client does take issue with certain discrete elements of DECA's assessment of impact, and we go on to address those in the body of the submission, what we do note at the outset is that DECA's ultimate position is closely aligned to that of the expert evidence or expert witnesses that have appeared before the committee, and with the proponent's position as reflected in the proposed incorporated document expressed a moment ago. And so in our submission, that degree of consensus, that is the degree of consensus between the expert evidence that you've heard and the peak state authority charged with managing Victoria's biodiversity, should be something that is attributed a considerable weight by the committee insofar as it demonstrates the capacity, the clear capacity in our submission for this project to respond properly to the ecological values of the project area and its capacity to achieve acceptable outcomes. Now, I'd like to make 2 further observations before moving on from this part of the submission. DECA, of course, is the Department of Energy, Environment and Climate Change. And in that capacity, DECA also made submissions in respect of the extent to which this proposal would be consistent with the state and federal ambitions in respect of emissions reductions and associated initiatives. And there was some suggestion from certain submissions or submitters that that gave rise to a conflict on DECA's part, and that DECA can and in fact has defended itself in that regard. But the observation that we wish to make for present purposes is that is not a conflict of interest. It is an inherent part of the exercise that this committee need undertake. That is, this committee is charged to have regard to those other overarching state and federal objectives in respect of greenhouse gas emissions reduction and in respect of the transition in the national electricity market, and to integrate those matters with the consideration of ecological impacts in the manner that, in our submission, the proponent has performed throughout this process. The second matter I wish to raise before moving on is that we'll come in a moment to examine the question of weight, that is, the weight that can be attributed to submissions made in opposition to the project. But in my submission, when the committee comes to consider that question, that is the question of weight, it need consider what sits on both sides of the ledger. And on one side of the ledger, in our submission, the committee must properly recognise that it has before it independent, peer-reviewed evidence concerning each of the relevant species of concern, and furthermore, the capacity to acceptably manage impact through the EMF, incorporated document, and the BAM. That evidence has been tested over the course of 5 days in this hearing process. We were very deliberate in structuring this hearing to ensure that an appropriate amount of time was allocated to the various topics to allow them to be fully considered and fully tested, and in our submission that is what occurred. That evidence was tested, as we mentioned a moment ago, by a number of parties, including DECA, which has the relevant responsibilities we've identified a moment ago. And the fact that we have DECA having tested that evidence indicating its satisfaction about the capacity for the effects of the project to be appropriately managed through an incorporated document, EMF and BAMP, in the manner that is proposed, consistent with the evidence, is a very weighty matter that need be considered. That is, when one considers the positions that are advanced in opposition to the project, particularly as they concern ecological matters, they need be considered in light of what is, in our submission, a very clear consensus in expert evidence and in the position expressed by the relevant authorities. What we next do in our written submission is set out in writing the changes that we have sought to introduce in response to DECA's position in both the incorporated document and the EMF. You've heard an explanation from Mr. Wright this morning, and so I don't propose to spend a great deal of time on this part of the written case. I do note, though, that at paragraph 14, we've summarised the relevant points of departure, to the extent that there are any, in the incorporated document, first at subparagraph A, and then in the EMF, second in subparagraph B, and they are consistent with the matters that Mr. Wright addressed a moment ago. I do make the observation that those points of departure are relatively minor, having regard to the broader extent of changes proposed by the department. What we then do in the written submission is set out some observations in respect or in response to the particular submissions made by the department on certain discrete topics. And the first discrete topic is the submissions made concerning native vegetation removal. And you'll see at subparagraph 7 that the document we're referring or responding to is document 393, which is the department's closing submissions delivered by Mr. Tobin. And there were really three matters that the department raised in respect of native vegetation loss. The first was the relevance and weight that should be attributed to Mr. Galbraith's evidence. The second concerned the manner in which native vegetation removal should be addressed in the EMF. And the third was the degree of certainty that exists in respect of the capacity for my client to provide the requisite offsets. And what I can indicate is that the second and third matters have to some degree fallen away. That is, the manner in which native vegetation removal should be addressed in the EMF. You've heard our position in that regard. The department's position, as expressed within its Day 2 documents, it seems to us differed from the position that it expressed in writing. We'll wait to see what the department says in response to the model that we've proposed in the incorporated document that was identified a moment ago, a position that is based upon and consistent with the permission granted in respect of the Golden Plains wind farm. But we don't anticipate there to be a great substantive difference between the department and my client in respect of those matters, but we'll wait and see. The third matter, the degree of certainty that exists in respect of the capacity to provide the requisite offsets, we've sought to have some engagement with the department about that. We say that the matters set out in Technical Note 15 adequately address those matters. We have agreements in place. There's been some toing and froing between my client and the department about the provision of those documents in a way that would protect confidential information. But for the purposes of this committee, we rely upon the matters recorded within Technical Note 15. We note also that we anticipate that that extent of offsets will ultimately not be required given the nature of what we anticipate to be the actual loss of native vegetation along the route. And so what that leaves really is our response to Mr. Galbraith's evidence, or our response to the submissions made in respect of Mr. Galbraith's evidence. And really the principal matter that we're responding to here is the characterisation by DECA of Mr. Galbraith's evidence as being opinion evidence. You recall that characterisation was advanced in support of a proposition that Mr. Galbraith's evidence should not inform the committee's assessment of impacts, that is, that it should not be attributed considerable weight. In this part of the submission, that is from paragraphs 16 through to 22, We explain why in our submission the committee should not adopt that approach. The key point is the one contained at paragraph 19. And there we note that Mr Galbraith, being a qualified arborist with decades of experience in assessing the impacts of construction on trees, being a person who expressed independent expert opinion before the committee, should be attributed considerable weight. That is, the opinions expressed by Mr Galbraith should be attributed considerable weight. That evidence was prepared following a site inspection conducted by Mr Galbraith. It adopted sound reasoning based upon Mr Galbraith's long professional experience and field observations, and it was tested under cross-examination. And so pausing there, to suggest that somehow it should be attributed lesser weight because it was opinion evidence, in our submission is a curious proposition to advance. It is opinion evidence. It's the opinion evidence of a highly qualified independent expert based upon field observations and appropriate investigations. And so in our submission, it should be attributed considerable weight, particularly in the absence of any competing evidence. At 20, though, we do make the observation that to some extent the matters that have arisen during the course of the hearing in respect of the department's insistence on the capacity to perform deep ripping along Boiler Swamp Road perhaps overtakes aspects of the evidence given by Mr Galbraith. Why do we say that? We say that because if it is the case that DECA require the capacity to perform deep ripping on an intermittent basis for the purposes of maintenance, well, that points very strongly towards a conclusion that any routes that may exist underneath the roadway would be compromised over time if they haven't already been compromised. And we make that observation at the end of paragraph 20, that is, if deep ripping is an activity that DECA considers necessary to safeguard, as it said it did, this should, in our submission, substantially diminish any residual concerns about route impacts from the construction of the transmission line, which would occur from a much smaller footprint than would be required to deep rip the roadway in the manner that's contemplated. And so what does that all point to? In our submission, it all points to the committee accepting the proposition which we advanced right back at the, I think it was the second hearing day of this hearing, which is that the likely estimate, the conservative estimate of loss as recorded within the EES is likely to materially overstate the extent of impact, noting that even that extent of impact is relatively small having regard to a project of this scale and was an order of magnitude below that, for example, which was attributed to the Golden Plain Farm. Now, the next part of the written submission concerns bushfire access along Boiler Swamp Road. That was a matter, again, that was addressed by Mr Wright in addressing the EMF. Unless there are any particular questions from the committee, we're happy to proceed on the basis that that part of our submission is taken as read.
Yes, thank you.
Okay. It's 11:23.
Yes, given the time, I can see that the Ms Thompson is with us online, so I'm going to ask her to join us. Ms Thompson, can you hear me? And I understand Ms Thompson is still having some tech issues and may be wanting to, whilst she has her video on, to join us actually by phone with the audio. So
can you hear me now?
Yes, thank you.
Okay.
Ms Thompson, I'm happy for you to explain the matters that you wanted to raise with the IAC.
Yes. Yesterday, I sent through the sort of final observation of what I thought was still missing, excuse me, from public scrutiny as the committee drew to a close after long and hard work. And I'll just go through those individually. The most important thing
I'm just going to ask you wouldn't mind just being very brief, thank you as well. So.
Okay. Do you have a copy? Do you have a copy of what I said?
Yes, there was correspondence received by the IAC that we didn't accept and didn't table. So I understand that you're here to explain explain your position on that, and that we're able to provide you with a response to that. Okay.
Well, ideally, if this document that I sent through to yesterday is tabled, in the case that it is not, I find that the main points that are still unresolved at the end of the public examination of this project are, number one, the fate of the recovery fund. Exactly what is it? Is it $30 million over the life of the project, or is it 50,000? I'm going to ask you to
stop speaking. Can you hear me?
Yes.
Yeah, so I just wanted the opportunity is really to, I understand that you have tried to raise some concerns in further written submission, and as the office has advised that the IAC is not accepting any further written or verbal submissions from parties at this stage. As you'll be aware, this is the final day of the hearing, and the proponent is presenting its closing reply submissions that respond to the issues that have been raised by parties throughout the hearing. So it is actually too late in the process for you to provide further submission, although, of course, as I mentioned earlier today, the IAC will accept comments on the project documents, and I'll talk to that again later today, and we'll provide written advice on that following today's hearing. So I'm not inviting you at this stage to provide written further verbal submission or to talk through the issues that you raised in your letter, on the basis that we have advised on several occasions that we won't accept further submissions from parties at this stage.
So what actually do you want from me if I can't?
I don't need anything particularly from you, Ms Thompson. The opportunity is to raise issues in preliminary matters, which we're following up now. So if there's a particular thing that you wanted to raise, it wasn't to talk us through the submissions, but I understand that you weren't satisfied with the IAC not accepting your further written submission. So we've provided you an opportunity to talk about that, and I've explained the IAC's position.
I don't really see there's anywhere for me to go on this. I just think that the committee is missing extremely important. There are gaps in knowledge about very strategic and significant matters raised, and now the committee will go into confidential stage. I understand that, but these gaps in knowledge are outstanding and are now without any public scrutiny.
Thank you.
It, really.
Ms Thompson, and I understand you had concerns further relating to the flyways with the Australian Bittern and the Ecology Fund, and the proponent will be talking us through its position on those today. And as I've mentioned previously, the IAC will consider all of the material before it and apply its own expertise in assessing the issues before it. That's. I probably don't have anything further to add.
Okay, thank you for the opportunity.
Thank you, Ms Thompson. Well, we'll break now for 15 minutes. We'll come back at 11:45 to continue his submission. Thank you very much. Muted. Great, thank you, Mr. Chessel. Hand back to you.
Thank you. We'll pick up, please, at the bottom of PDF page 11, where we commence by addressing the submissions made by DECA in respect of impacts of the project on fauna. And we start by responding to submissions made by DECA about the adequacy of the information in the EES and as supplemented by the materials that are before you now. And at 34, we make an observation that we made in our closing submissions, which is that this committee has before it more and more detailed information about the existing conditions and likely impacts of the key species of concern than any other panel or committee that has considered a wind farm proposal in this state. And if we just pause for a moment, we say that not just because this is an EES prepared over a number of years, but you'll recall the evidence given by Mr. Organ in his capacity as independent peer reviewer about the nature and extent of the survey effort and indeed the impact assessment effort as recorded within the EES. And Mr. Organ explained that that effort was greater than for any other project he was aware of. And we asked the committee to bear those comments in mind when you come to consider the submissions made by other parties that seek to contend or that sought to contend that inadequate survey work had been done or that there were certain deficiencies in the survey work. In our submission, those contentions don't withstand scrutiny when one considers the full extent of analysis that informed not just the EES but the further process that has been completed before you. At paragraph 35, we make reference to the different phases of assessment. The first, of course, was the very lengthy process of pre-assessment undertaken through the TRG process. DECA, of course, was an active participant. It was a process that occurred over a number of years with multiple rounds of consideration and resubmission of information before the EES was placed on exhibition. And sometimes, in my experience, that pre-assessment process is downplayed or ignored, but the purpose of the TRG process is to ensure that the EES placed on exhibition is an EES that is adequate and appropriate for consideration by a committee of this type. And the fact that this process was a process that included so many iterations is testament to the fact that the EES materials before you are thorough and comprehensive. Then what followed that process was the exhibition of the EES. It was for an extensive period of time. Of course, there were 214 submissions made in full. About a quarter of those have sought to participate actively in the hearing process. And this hearing process itself is a process that has involved extensive consideration of evidence. We've got 15 expert witnesses on behalf of the proponent. As we mentioned a moment ago, there was detailed cross-examination of many of those witnesses, including by relevant authorities and by a number of individual submitters. And we observe, as the committee will no doubt be aware, that processes, that is the hearing processes of this type, are important components of the public assessment called for under the relevant statutory processes. It's orthodox for new and revised information to be adduced during a public hearing process of this type, including through evidence and the provision of technical notes, including in response to issues ventilated in the hearing process and indeed in response to queries raised by the committee itself. And at 37, we observe that DECA has expressly confirmed that the ongoing analysis that it calls to be undertaken can be addressed through the EMF and mitigation measures And that's a proposition with which my client agrees. That is, it is necessarily the case in respect of a project like this that there will be appropriately ongoing assessment, ongoing monitoring, ongoing approval processes established pursuant to instruments like the EMF and the incorporated document. It is critical in our submission to understand that where we are in the assessment process, what the committee has before it is more than sufficient information to discharge its statutory functions. What should properly follow is a carefully framed, carefully implemented EMF and mitigation measure regime, which we note in this case is to be the subject of periodic audits by an independent environmental auditor. That is, the committee should have confidence that the regime established here is a robust and comprehensive one, and, as we'll come to explain, an appropriate response to any residual uncertainty about the extent of effects of a project like this. That is, an adaptive management regime, properly framed, properly secured pursuant to mitigation measures and the incorporated document, is a appropriate precautionary response to residual uncertainty that necessarily arises in respect of impact assessments of this type. At the top of PDF page 13, we seek to respond to submissions made by DECA concerning the Southern Bentwing bat. They seem to fall within three categories. The first being the relevance and reliability of the recent ARI publications and the academic research. The second being the extent of risk posed by the project to that species. And the third being the appropriate response to residual risk under the EMF and BAMP. And we note really that the second and third of those items are matters that it seems DECA and my client are aligned on. That is, DECA, like my client, accepts that there will be a degree of risk and that the appropriate response to that residual risk is by implementation of the EMF and the particular measures proposed under the BAMP. For that reason, I'll focus this morning on addressing on the first of those matters, that is the relevance of the ARI publications and the corresponding academic research. And what DECA cautioned against in its submissions was placing determinative weight or determinative reliance on those additional materials. And we simply observed that we don't disagree with that proposition, nor have we ever contended otherwise. What we were hopefully able to convey to you is that we sought to rely upon those additional materials to the extent that they complement and confirm the very detailed assessment of impact on southern bentwing bat recorded within the EES. And you recall the extent of survey effort that had informed that aspect of the EES. And you recall that that was correctly described as being more comprehensive than any other comparable assessment for any other wind farm project. And what we point to in respect of the ARI material and the academic research is the very clear extent to which the findings of that material are consistent with and bolster the independent research and assessment undertaken and recorded in respect of this project. That's why that material is of consequence to this assessment. We do, at paragraph 42, make the observation that it's important to properly understand the true import of that additional research. And we say that because when DECA made its submission, it was at pains to, or it characterised that material as suggesting that most flights, or separately the majority of flights, would be below rotor swept height. Well, that's correct, but in our submission, it is really too blunt a characterisation of that research in that it is a material understatement. To be a majority, it need only be more than half, right? But when one carefully reviews that material, what one sees is that it provides support for the proposition that it is the vast majority of flights that are likely to be below rotor swept height. Indeed, well below 1% of total flight movements. That was the conclusion drawn from the assessment undertaken in the EES, and it was bolstered, that is corroborated, by the separate assessment undertaken by ARI and by the relevant academic literature. Well below 1% of flights should be anticipated to interact with the rotor swept height. Then there was a separate suggestion by DECA that there was some uncertainty about flight height data in treat environments. And again, I just encourage the committee to carefully review document 175. That's the academic paper that's been submitted for publication. I'm not sure whether there's any advance in that over the past 6 weeks or so. But what that data clearly indicates is that even when one has regard to the uncertainty about flight height within treed environments, the proper conclusion is still that the vast majority of southern bent-wing bat movements in treed environments will be below the rotor swept height. That is, the existence of treed environments doesn't bear upon the conclusions drawn within document 175. And we encourage the committee to review that document carefully. No doubt it already has already. What we do note, though, is that that is a document that is prepared, academic research prepared, specifically for the purposes of identifying appropriate mitigation measures for this type of project within this part of Victoria. And what that paper concludes, having regard to the research that was undertaken, is that curtailment in the form of cutting wind speeds, that is cutting wind speed curtailment, is an appropriate means of properly responding to the risk posed by projects of this type within southwestern Victoria. And of course, that is exactly the type of measure that the BAMP would require, with protocols for ramping up cut-in wind speeds should mortalities be detected, or conversely reducing cut-in wind speeds should no mortalities be detected over time. That is an adaptive management response. And so again, this research is relevant to the extent that it corroborates or bolsters the basis upon which the assessment has been undertaken in respect of this species as documented within the EES. The next topic that we address in the written submissions is the submissions made by DECA in respect of the Australasian bittern. We pick that up at the bottom of page 14. And what we first do at paragraph 52 is respond to a number of propositions that were set out within a particular part of DECA's submission. We're going to come back and address you on the Australasian bittern in more detail later in the submission, so I won't spend a great deal of time working through these matters. But what I did want to identify for present purposes is the matter that we address at paragraph 52 at subparagraph D. And in that paragraph, we respond to a proposition raised by DECA in respect of pre-commissioning monitoring and the utilisation of advanced technology to inform adaptive responses. And if the committee just makes note for present purposes that in document 483, which is the incorporated document marked up, the day 3 document that we took you to earlier today, that clauses 20 subparagraph D, E and F of the incorporated document, I think I've got that reference correct, that those clauses give effect to the submission made by DECA in respect of what DECA described as the presumptive application of this type of advanced technology in respect of the Australasian bittern, that is both in respect of monitoring and operation. You recall that there had been a difference between my client and DECA in respect of the extent to which the EMF should presume the application of that type of technology, both for monitoring and application. My client had originally proposed that it be utilised in circumstances where it could be demonstrated to be proportionate and appropriate. What DECA called for was no, a requirement that it be implemented unless it could be demonstrated to not be required as being proportionate or appropriate, so a shift in emphasis. And what we have sought to give effect to in the incorporated document is the DECA position, modified in the way that Mr Wright described, to align that position with the submission made by DECA. I wanted to bring that to your attention because the utilisation of technology of that type as a basis to inform pre-commissioning monitoring initially, and potentially ongoing monitoring or curtailment, should it be demonstrated to be necessary or appropriate or proportionate to the risk, is a matter that was addressed in 2 documents that were filed before you. And you'll see at subparagraph E that we've set out reference to those 2 documents. You recall that we prepared a technical note concerning the potential application of this type of technology, and that attached to those technical notes were 2 memoranda that were prepared in the context of particular types of technology, the first being identified, the second being the radar technology advanced by DHI Muse. And we wanted to bring this document again to the committee's attention, particularly as it concerns this aspect of the assessment, that is the application of this type of technology to inform pre-commissioning monitoring and, to the extent it is demonstrated to be appropriate, some form of ongoing monitoring or curtailment. And document 224 was the paper prepared by Identiflight. And we note at subparagraph capital A that one of the things that paper does is confirm the success of that technology at the Cattle Hill wind farm in Tasmania, in that case to address impacts on raptor species. At subparagraph B, we note that while the current technology operates from dawn to dusk, that is, the camera-based technology relies upon light, the paper clearly identifies that nighttime detection systems for nocturnal birds and bats are under development, and expresses confidence about that technology advancing in the short term. And again, we've included PDF page references should the committee wish to go back and review these parts of the document. But what the document also does is, specifically in respect of the Australasian bittern, describe a proposed monitoring study program that would be implemented pre-commissioning, utilising mobile camera units with nighttime vision capability to validate a detection methodology and species identification for the bittern, to then track flights over a period of about 12 months to characterise flight heights, trajectories, dispersion and quantity and timing of flights in the way that we described. And then in subparagraph D over the page, to identify the effectiveness of that technology for pre-operation monitoring of species of concern to inform turbine and camera placement. The reason I wanted to bring this document to your attention again is because, in light of the position that we've sought to give effect to under the incorporated document, where there is a presumption that this type of technology would be utilised to inform pre-commissioning monitoring, you have before you a detailed description of how that program would be properly constructed and implemented, and why it is that the committee should have confidence about the capacity for that type of technology to respond. One of the things we haven't mentioned in the written submission that is addressed in the written document itself is the capacity to utilise the relevant network established for the Eurasian bittern as a basis to inform the identification of the Australasian bittern. And at the next paragraph of the submission, we make reference to document 225, which is the document prepared by DHI Muse, which is the technology that uses both radar and camera-based systems, that contains, again, explicitly detailed analysis of how that type of technology could be utilised in a manner that is contemplated under the Day 3 version of the EMF, including how it is that a monitoring program described as a pilot program in that document would be constructed and implemented to collect baseline data for species of concern. And so if we pause there for a moment, members of the committee, in our submission, as we'll come to address in response to the submissions advanced by the Trust, based on the information, that is the best information available to this committee, there is no proper basis to contend that somehow nationally significant flyway exists across the subject site. But notwithstanding that there is a degree of uncertainty about the nature and extent of movements of this species across the site, which the witnesses properly described as being infrequent and irregular, the appropriate precautionary response in light of that uncertainty is to prescribe an EMF or an incorporated document that calls for the preparation of a BAMP that in turn requires, as this control would, the implementation of the best available science, the best available technology to continue to monitor the prevalence of this species on this site and to implement adaptive responses based upon the further monitoring. And in our submission, contrary to propositions that were advanced against the project, high-level propositions that somehow this project was inconsistent with the precautionary principle, instead, in practice, in operation, what that principle calls for is precisely this type of detailed monitoring program and adaptive management program, overseen, we note here, by an independent environmental auditor. That is the operation of the precautionary principle in practice. At paragraph 53, what we note is that DECA ultimately confirmed that, subject to the implementation of the offset strategy and the revision of the BAMP in the way that we say is now reflected in the Day 3 materials, the matters that it raises in respect of this species can be resolved via secondary consent. That, in effect, is consistent with the submission that I made a moment ago. I suppose the difference between my client and DECA in respect of this species is whether or not we accept as a starting point that this project would result in a significant impact. So you recall that Mr. Organ's evidence was that the proper view is that it should not be considered to meet that threshold. Mr. Van Noster's position, as expressed within the EES, was more cautious, saying it probably fell on the other side of that threshold, such that it would constitute a significant impact, in which case the relevant offset would be formally required. DECA preferred Mr. Van Noster's position. Ultimately, of course, a matter for the committee to consider as to where on that side of the line the committee sits. But what we have sought to demonstrate throughout the course of this hearing is that even were it considered to sit on that side of the line, that is, to constitute a significant impact for the purposes of the EPBC Act, this is a location where one can readily identify opportunities for offsets to be delivered. And we have, following that evidence, advanced discussions with the owner of Block 7. And you recall that we advised that letters of intent had been exchanged such that the committee could have or can have confidence that an offset of this type can be provided in the immediate vicinity of the site should that ultimately be considered to be necessary. We address that at paragraph 54. The next topic we address is the submissions made by DECA concerning the Brolga, and we note first at paragraph 55 that DECA's submission we noted the submission made by DECA concerning its satisfaction with the assessment process completed in respect of the Brolga. At 57, we have accepted DECA's suggestion that the compensation plan requirements be relocated from the EMF into the incorporated document. The only difference between the proponent and DECA related to the collision risk modelling and the PVAs explained by Mr. Wright earlier today. We don't understand that to be a disagreement of substance, but rather a disagreement principally in respect of the form of that requirement. The key matter that I would like to emphasise for present purposes is that set out in paragraph 58, and that concerns the power line options, the internal transmission line options around Headage Hill. And my client notes or recognises that a portion, but only part of, that central option would be situated within the movement buffer identified in respect of Brolga. And should that portion of the central alignment be of concern to the committee, then it would be the case that a hybrid option whereby part of the central alignment would be provided above ground and part below ground could feasibly be pursued. So if we just pause there to make this point clear, you recall, Member Kirsch, you asked questions about were the central alignment option to be pursued, was it feasible, and had investigations been undertaken as to whether the transmission line, the power line in that location could be underground? And we indicated that yes, those investigations indicated that it was feasible, but that our preference was that it be above ground for the reasons we identified. If the committee was against us in respect of the appropriateness of the central alignment being above ground, and in our position it should not be, but were you to be, then there would be the potential for a portion of the central alignment to be delivered below ground, in particular that portion through the movement buffer or the movement corridor, and the balance to be above ground. That is, that would be technically feasible and would be a preferred outcome than a requirement that the entirety of the alignment be below ground. Now, at 59, we have sought to maintain our position that the appropriate option is the central option above ground, and we note that DECA's position in that regard was that the central option is, to use their words, not a stop sign. Now, in paragraph 60, we make reference to the response provided by DECA to the committee's queries concerning whether there's any evidence in support of the assertions made about displacement, which of course was the focus or a focus of much of the submissions advanced by a number of parties before the committee. And in short, we agree with and rely upon the response provided by DECA in that regard. We, in emphasising or addressing this point, we sought to note the following matters. Firstly, the committee should recognise that displacement is, contrary to submissions made by a number of other parties, an effect that both the interim guidelines and now the handbook identify as being a potential impact on Brolga from wind farms. That is, when one reviews the interim guidelines in particular, you'll see references to measures to address disturbance. And disturbance, of course, includes both direct impacts but also indirect impacts. And displacement is undoubtedly a manifestation of an indirect impact on this species. And why are we pointing that out? We're pointing that out because the interim guidelines and now the handbook identify or delineate a particular response to address those types of impacts, that particular response being the application of a 300-metre additional disturbance buffer around the buffers established in respect of breeding and flocking sites. That, of course, is what has been implemented in respect of this proposal. We note and submit that it is significant that DECA has expressly endorsed the approach that has been adopted here as being consistent with the current state of scientific knowledge. And we, of course, note and say that it is significant that DECA is satisfied with the buffers that have been proposed in respect of this proposal when assessed pursuant to the terms of the interim guidelines. We don't just rely upon DECA's position in that regard. We note that it is consistent with the expert evidence given to you by Mr Van Oster and Mr Organ. We've got more to say about the Brolga in due course, and we'll come back and address you further. The next species that DECA addressed that we wish to respond to was the southeastern red-tailed black cockatoo. And in our submission, DECA's position that it was premised upon the prospect of this species moving to the south of the site to utilise Lake Monbiong or for some other purpose, really wasn't consistent with what was the best evidence concerning the prospect of impact on this species. In particular, we rely upon the evidence given by Mr Organ and Mr Gibson in respect of that species, both of whom did not discount the possibility that movements may occur over time, infrequently, at very low numbers, but which recognise properly that the likelihood of any such movements by this species across the site is very low, and that even if such movements were to occur, they would most likely be below rotoswept height. And in that latter respect, that is the propositions advanced in respect of flight height, we note that the best empirical evidence of flight heights for this species is that movements would be materially below the minimum rotoswept height of the turbines, and no party has presented any evidence whatsoever to the contrary, nor identified any compelling reason why the species would fly such a significant distance above the maximum height of the canopy of the trees within the plantation. That is, even if movements were to be made on an irregular basis across the plantation site. So in our submission, we take issue with aspects of DECA's reasoning in the submissions that it advanced, but again, ultimately, we endorse DECA's proposed course forward, which is to implement a EMF and a BAMP that would require appropriate monitoring and adaptive responses should there be a risk demonstrated to emerge contrary to best evidence that is before you. And that really is the proposition that we advance in respect of the other species that were the subject of DECA's submission. Again, we note properly that DECA recognised the regime to be established under the EMF and the BAMP was the appropriate way to address any residual uncertainty that may exist in respect of the potential impact, noting the extent of assessment that has informed the EES and the materials before you. I'd like to move now to the submissions made by Parks Victoria, and the first thing we do is note that in document 458, Parks Victoria suggested a number of changes to the EMF and project documentation, and we've implemented all of those in the day 3 materials. The next thing we do is identify that in certain respects, at least, Parks Victoria's case or interest in the project can be broken into 2 parts. There's the interest that arises by virtue of the application under the National Parks Act, and there's the interest, the broader interest that exists by virtue of what's described as the Parks Estate, the Parks Victoria Estate, the Walk, the Swan Lake Campground and Lake Monbiong. We have set out our response to the National Parks Act matters In the first part of our written reply, I'm not going to address you on those matters. There were some lengthy submissions made by Parks Victoria about the operation of that Act. We rely upon the matters that we addressed. I don't think ultimately there's a great deal of difference in the way that Act should probably be construed. At PDF page 22, partway down, 2/3 of the way down, we addressed the key question about whether or not this project, and in particular the transmission line, would substantially affect the Kembruck National Park. We note that Parks Victoria did not submit that that would be the case. At paragraph 76, we provide certain responses to issues that were raised by Parks Victoria that warranted consideration. I'm happy to rely upon the written response in those regards. Ultimately, you'll see at the toward the bottom of PDF page 24 that in our submission, having regard to the matters that we have summarised at paragraph 77, being matters that we addressed in closing, this really is a case where there is no reasonable basis to argue that the construction of the transmission line may have a substantial effect on the park. Pausing there, this would be a very different case were the transmission line not to be situated beneath an existing road corridor. I mean, the extent of impact would be materially greater than is the case here, but because of the very obvious benefits that exist by co-locating infrastructure, linear infrastructure of this type, what the committee can confidently conclude is that the impacts of this component of the project would be relatively minor and certainly not amount to a substantial effect for the purposes of that Act. DECA did make reference to the Barwon Water Pipeline project. We addressed that at paragraph 78. We've explained why, based on the information that's publicly available, in our submission, the extent of actual and assumed impacts for that project is materially different to this project. And really, it stems from the fact that, in that case, there was not so significant a roadway as exists in this case, that is a cleared road corridor of considerable width that ultimately is, as DECA explained, either subject to or potentially subject to deep ripping on a periodic basis. The next thing we address in the reply submissions is the submissions made concerning the options assessment. Again, we can deal with that relatively quickly. We say it is of no consequence to the assessment under section 27. At paragraph 83, we respond to the proposition to the contrary to the extent that was advanced by Parks Victoria. In our submission, when one reviews the legislative framework, it is quite clear that the matters contained within the options assessment are not matters that bear upon that statutory decision-making framework. Instead, what the Minister must ultimately be satisfied is the question of substantial effect, as opposed to whether or not there are other alignments that may or may not result in impact on the national park. The next aspect of the Parks Victoria submission that I'd like to address in reply is the submissions concerning landscape and visual impact, and they're set out at the top of PDF page 26. And we note that at paragraph 100 of its submissions, Parks Victoria suggested that the Swan Lake and Lake Monbion campgrounds rely heavily on the landscape setting and uninterrupted views across the coastal hinterland. And we've sought to interrogate that proposition in the submissions that follow. What we first do at paragraph 86 is address that proposition in the context of the Swan Lake campground, and what we observe in this regard is that from that campground, it is true that there are views available to dunes to the south, with scrub and agricultural land visible in most other directions. And so it's not entirely clear to us what Parks Victoria means by uninterrupted views from this location, or why that concept is relevant. The landscape setting visible from the campground is, in our submission, quite clearly disturbed from a natural state. It includes roads. Very clearly, it includes agricultural infrastructure and dwellings in the long distance views from the campground, and in respect of which the turbines would only be visible in a relatively small part of a much larger viewscape. And from some parts of the campground, specifically the walkers' camp, views of the turbines are likely to be very limited, if available at all, due to existing vegetations. Then, of course, it is relevant to consider views from the dunes themselves, which we walked up into part way, but of course they're an extensive dune complex. And you recall that that is an environment that is subject, at least periodically, to use by the Dune Buggy Club. It's that in our submission results in that location having a fundamentally different character and amenity from other campgrounds that are relevant to the assessment. There will be views, of course, to the turbine array from the dunes. The nearest turbine will be in the order of 3 kilometres from that location, the furthest in the order of 28 kilometres. But those views are also across agricultural pasture land and across the plantation. From higher up on the dunes looking to the southeast, views already take in the Portland Wind Farm, which now forms part of those landscape views. And so again, we're not contesting that there will be an impact, that there will be an impact. From Swan Lake Campground, in our submission, that impact will be of a lesser character than the impact from the more immediate views from Lake Monbion. But we do submit to the committee that it is important that any assessment of impact be an objective one, having regard to the range of landscape characters that are immediately apparent from the Swan Lake Campground. And for the reasons that we've addressed in paragraphs 86 and 87, those characters are mixed and are undeniably characterised in part by exotic landscapes, that is, the plantation or agricultural landscapes, and are not purely, as some submitters have sought to suggest, natural landscapes exclusively. At paragraph 88, we conduct a similar exercise in respect to the Lake Monbion campground. In our submission, views from that campground are more truncated. They look to the surrounding terrain and plantation rather than providing longer distance views. I think that is a matter that is immediately apparent when one visits the two campsites. You've heard evidence and submissions from us about the impact of views from that campsite. We accept that those impacts are high, and we've provided an analysis of why those impacts are reasonable in the context of the project. We rely upon those submissions, we rely upon the evidence of Mr Hark, and we rely upon the matters set out in Technical Note 36. We note that that assessment didn't seem to be actively contested by Parks Victoria. What we have sought to do in this part of the hearing is engage with Parks Victoria and have engaged with Parks Victoria with a view to identifying the types of mitigation responses that could appropriately be implemented in this context to address the impact. Those measures include vegetation screening, upgraded infrastructure, a new jetty at Lake Monbion. And we do note that these sorts of responses are responses or measures that are routinely undertaken at campgrounds around the state. There is clear benefit in our submission for the facilities at that particular campsite to be upgraded. The benefit that in our submission would offset or at least ameliorate aspects of the visual impact of the project. And to that end, as we identify in paragraph 90, we've met with Parks Victoria. Parks Victoria suggested changes to the relevant mitigation measure, and we've adopted and accepted those changes in the Day 3 materials. The next matter that we respond to from the Parks Victoria submission concerns the position advanced in respect of noise. And the first matter we wish to address here is that submission that was made on behalf of Parks Victoria failed in our submission to have proper regard to the applicable statutory context. You recall that in opening our submissions in respect of this part of our case, we took you to the relevant provisions in the Environment Protection Act. And we say that it's telling in that context that Parks Victoria did not contest the proposition that the project would comply with all applicable noise limits, or that compliance with those limits would ensure compliance with the general environmental duty, and, or I should say, any other aspects of the legislative regime established under the Environment Protection Act. So that really is the starting point in our submission for the committee's assessment. Then there's a question about should additional background noise measurements be required. You heard the explanation from Mr. Dallaire as to why the only possible consequence of undertaking background noise measurements would be to increase the applicable noise limits rather than reduce them. Why? Because the baseline noise limits were adopted for the purposes of the assessment. So it seems to us that there should be no strictly formal requirement to undertake further background monitoring, but that said, we don't take issue with doing so if that's considered desirable by the committee. And you'll see at paragraph 93 that we've addressed that in the EMF. The more substantive issue that arises or that exists between my client and Parks Victoria in respect of noise is the proposition advanced by Parks Victoria that the campground should be treated as a high amenity area for the purposes of the New Zealand standard. We address that at paragraph 94, 95 and 96. The starting point in our submission should be to recognise that Mr. Dallaire explained why he did not consider that the campsite would qualify as such by reference to the standard. And we make the observation as well that Mr. Dallaire's report was peer reviewed and that the approach was endorsed and considered appropriate by that person. We note also that the EPA indicated that they did not wish to make submissions in respect of this matter, and it's quite clear, we say as a consequence, that the EPA has not sought to contest the characterisation of the campground in the way that the Marshall Day report did. So what's the case to the contrary? Well, the first thing we note about the case to the contrary is that Parks Victoria in its submission put the proposition no higher than that it would be open. It would be open to conclude that the campsite should be treated as a high amenity area. In our submission, Parks Victoria's position in this respect derives no support, not only from the expert evidence, but also it derives no support from any published decision of a court or tribunal, any panel decision, or, importantly, from the terms of the New Zealand standard itself, which identifies that a high amenity area must be an area where a plan promotes a higher degree of protection of amenity related to the sound environment of a particular area. And that just simply does not exist in respect of the campground. There is no special designation in a plan, be it under the planning scheme or otherwise, elsewhere, that says somehow this particular campground, or campgrounds in general, should warrant a higher level of protection than other areas. And so in our submission, the designation of that area as not being a high amenity area is the appropriate one for the purposes of the assessment. But ultimately, in this case, to some degree, the question is moot. Why do we say that? We say it because Mr. Dallaire demonstrated that even if that campground was treated as a high amenity area such that the applicable limits were lower than would otherwise be the case, so that the baseline limit would be not 40 decibels but 35 decibels, that this project would comply. That is, that the relevant noise levels would be below the levels that would be applicable to a high amenity area. You've got to understand that those levels only apply in respect of wind speeds at a certain, I think it's up to 6 metres per second, after which it defaults back to the 40 decibels, and the monitoring or the modelling undertaken demonstrates that that transition would be complied with in the current case. And so in our submission, as a matter of principle, the campground should not be treated as a high amenity area, having regard to the statutory framework. Even if it was, though, substantively, what the material demonstrates is that the level of noise would comply with those limits. And that just goes to further demonstrate in our submission the limited extent to which this project would impact on the noise environment within the park. That is, even under the cumulative worst-case noise conditions that inform the modelling for the project, the level would be below the level afforded the most sensitive locations within this state. Now, we next address the submissions made by the council. We start by responding to submissions concerning amendments to the EMF. Again, Mr. Wright has responded to those. The points of difference, if you like, concern the treatment of the Community Benefit Fund. We do not consider it appropriate that the council, pursuant to the statutory document, have a direct role in oversight of that fund. We take no issue with the proposition that the council should be consulted in the formulation and implementation of the fund, but we say that this is not a fund that is appropriately overseen by the municipal council. Submissions were made concerning worker accommodation, and in particular there was a call for the plan to focus worker accommodation within the municipal area as opposed to within Mount Gambier. In response to that, we simply rely upon the evidence of Mr. Weston, who explained that there would be benefit in ensuring appropriate utilisation of both areas, and that's what we've sought to implement through the relevant mitigation measures. Then the third thing addressed by the council really concerned impacts on its infrastructure, and we've set out a response there. That is, we say the mitigation measures adequately protect council infrastructure through construction and operation. The CFA made submissions, including submissions that sought to modify aspects of the EMF. We've implemented all of those, with the exception that we have modified the requirement in respect of the lightning production systems. So rather than it being a presumptive requirement, it should be something that is appropriately considered as appropriate in respect of the ultimate turbines to be selected. We have furthermore, as we've identified in paragraph 107, ensured that the EMF is adaptive to changes in the guidelines over time. At subparagraph B, we have given effect to CFA's position in respect of vegetation management. You recall that that was potentially an issue between my client and the CFA. The CFA's ultimate position is that the relevant vegetation management response will be dictated by the ultimate model of turbines that are to be chosen, and that is to be informed in part by the fire detection and suppression technologies utilised. We don't take issue with that proposition, nor do we take issue with the proposition that the ultimate treatment of vegetation management should be one considered at a detailed design phase in light of the ultimate technology to be proposed. And we've noted at subparagraph C that the CFA has recently confirmed, in response to the query from Member Joyner, that it was not aware of wind farms having any impact on communications equipment used by the CFA, which is consistent with our understanding. And so what one sees then is a set of day 3 controls that give effect to the position expressed by the CFA, that is what the CFA identifies as being necessary to appropriately respond to the risk posed by bushfire and the interaction of that risk with this project. It's a matter we'll come back to in responding to the submissions advanced by the individual submitters in respect of bushfire risk, but of course it is relevant that the CFA's position is so clearly at odds with the individual submissions that were advanced in respect of the capacity for this type of project to respond to the particular characteristics of the environment as it concerns bushfire risk. What one sees here is a project that has responded to the guidelines issued by the CFA as they concern the appropriate measures, that has then been tested by the CFA, and the committee has before it a series of mitigation measures and an EMF that in our submission gives effect to the appropriate requirements. The EPA, there's not much to say about the EPA other than that EPA had made a written submission. It then opted not to participate in the hearing. It did, we note, remain on the distribution list, and so had access to all relevant documentation. Obviously had an opportunity to review the filed material. It's elected not to participate further in the process, and in our submission that should be evidence that it does not have any material concerns in respect of the proposal. And so where does that leave us, having completed the review of the statutory authority and agency submissions? Well, in our submission, what it clearly indicates is that this is a case where, and it is significant that, none of the state agencies and authorities that have participated in this hearing process have submitted that the project should not proceed, not one. And that's unusual in our experience in respect of a project of this type. That is, where a relevant agency or authority considers that a wind farm or other like project should not proceed, they say so. And what one sees here is that the position that's been adopted is that supportive of a conclusion that the assessment in the EES is an appropriate one, that it satisfies the scoping requirements, and that this is a case in which, subject to the implementation of the incorporated document and EMF, this is a project that should be allowed to proceed. Okay, we'd like to move then to the second category of submitters that we respond to, and these are submitters that sought to raise matters of a technical nature concerning the ecological impact of the project. And in our submission, there were 4 submitters that fell into this category. Firstly, and most obviously, the Trust. Secondly, the BirdLife submissions, that is BirdLife South East South Australia, and BirdLife Australia. And then Mr Tuck, to the extent that he sought to address these matters, Mr Tuck, of course, being an ecologist who is also employed by the Trust. Now, the first thing that we note in this regard is that, consistent with the directions of the committee, my client re-engaged Mr Organ to prepare a response to the particular questions posed by the committee in respect of those submissions, those being the questions concerning the Australasian bittern in particular, and to provide comment in respect of other matters raised in those submissions more broadly. And we should here reference not just Mr Organ, but of course Mr Gibson, who also prepared a comparable review. And we, of course, rely upon, and I'm not proposing to repeat or rehearse that material. That is, what the committee has before it is a response to those technical matters raised by the submitters and prepared by the independent experts that appeared before you. And so, if we just pause there, one of the things that those responses do is explain why, amongst other things, the claims made by Dr Herring in respect of the potential impact of the project on Australasian bittern lack an evidentiary foundation and should not be accepted, including why the proposition that somehow this project would impede a nationally significant flyway it simply does not derive support from the evidence before you. And we rely upon those detailed explanations as our position, supported by the independent expert opinion, that those propositions should not be accepted. But what we're seeking to do in this submission, rather than address the substance of that material, where you have the substantive response, is address you on the question of weight. That is, what weight? How should the committee approach its assessment in light of the submissions that it has heard from these submitters, in light of the process established to assess environmental effects and the full suite of materials before the committee? And we do so first in the context of the submissions advanced by the Trust. And we understand and respect the ruling made by the committee in respect of allowing the presentations to be advanced by Nature Glenelg Trust. We note at paragraph 120, however, that in making that ruling, the committee indicated that it would treat the material as submissions, as it must, as opposed to evidence, and that it would attribute weight to those submissions accordingly. And so what we want to address you on this afternoon, perhaps before and after lunch, is how should the committee go about attributing weight to those submissions? And at paragraph 122, we identify what we say are 4 critical matters that the committee should take into account in coming to a view about this question of weight. The first is that none of the presenters can be taken to have appeared in their personal capacity. This is the point that I made earlier in the proceeding. So the committee cannot say it heard a presentation from Dr. Herring. It heard a presentation from Dr. Barrett, I think the other expert was. That is because they did not appear in their own capacity at all. They appeared as an advocate for a submitter being the Trust. That is, they were a representative of that organisation, as opposed to a person coming along, giving their own independent opinion and facing the scrutiny that necessarily follows as a consequence of adopting that course. That is, whereas an expert witness must appear in their own capacity, as Mr. Gibson has, as Mr. Organ has, as Mr. Van Oster has, and where they necessarily owe a primary duty to the committee as opposed to the party calling them to give evidence, none of the presenters making submissions on behalf of the Trust purported to do so. The second thing we wish to address is the contention made by the Trust that somehow the Trust was independent in the relevant sense. And in our submission, the Trust can't be considered independent, and that's evident from its own conduct. It elected to not participate in any way in the preparatory phase of the EES, despite my client having attempted to do so, and instead flatly refused to confer or consult with my client. Now, that's entirely a matter for the Trust, but it is relevant that at the very outset of this process, it indicated that it was opposed to the project, and having indicated that it was opposed to the project, it did not engage directly in our submission with either the published EES or with the evidence called before the committee. And in that light, the Trust submission was highly partisan, and in our submission didn't display any of the characteristics of an independent, unbiased position. And I suppose the third matter really flows from the second, and that is that it's simply not possible to test the substance of any of the presentations given by the Trust. And that's not simply a consequence of there being no opportunity for cross-examination, which of course would have been an opportunity that we would have taken up had that material been filed as expert material. But in this case, the presenters didn't prepare or file a witness statement in accordance with the directions. None of the presenters had regard to the practice note material, and that practice note material exists for a reason. That the relevant declarations are necessary to establish the bona fides of a expert coming before a committee like this, and the fact that there was no compliance with those matters is of consequence. Importantly, none of the materials that were advanced, and I'm now onto the fourth matter, none of the materials advanced were put to my client's witnesses for consideration and response either in cross-examination or before they gave evidence. And I suppose to the extent that was frustration on our part as to the course adopted by the Trust, it was in part as a consequence of the fact that we had sought so clearly to establish a framework throughout this hearing whereby issues concerning the impact of this project on species of concern could properly be tested through evidence. We devoted 5 days of hearing time to those questions. It was very clearly timetabled, and yet the Trust elected to not participate in that part of the process or to allow a full testing of those matters. And where in our submission that process has so clearly been established and very clearly communicated to the parties, it is highly problematic for a submitter to pursue the course that it did in this instance. Now, you recall that earlier today I indicated what sat on one side of the ledger, that is the peer-reviewed, tested evidence heard over the 5 days, bolstered in our submission by the position advanced by DECA. That sits on one side of the ledger. On the other side of the ledger then are submissions advanced by a party that were not able to be tested and that lack a proper evidentiary basis in our submission. And when one compares both sides of the ledger, what one sees in our submission is a very clear path through that reflects and responds to the best evidence before the committee and that acknowledges the position expressed by the state authority that actively participated in the proceeding. Now, I might just work through the next part of the submission and then it might be an appropriate time to break for lunch. To conclude, what we say at paragraph 123 is that not one of the fundamental and essential hallmarks of independent expert evidence was satisfied in respect of the opinions that were expressed by the 3 presenters. And as a consequence, in our submission, the opinions expressed by those presenters are no more than untested assertions in the nature of submissions without a proper evidentiary foundation. And for that reason, amongst the others that we've identified, the committee must, in our submission, treat that submission as what it is, a partisan submission from a self-interested party. Now, this is an expert committee. You can form your own expert opinions. In forming your own expert opinions, this committee must, in our submission, have appropriate regard to the weight of evidence and submissions before it. And in our submission, that weight clearly points toward the position as articulated within the Day 3 documentation and a conclusion that the impacts as identified in the EES are impacts that are appropriately mitigated and managed in the manner contemplated by the proponent. What we do in the balance of this part of the submission is identify examples of issues with the approach that we've taken with the submission made by the Trust. And the first of those issues is the assertion made by Dr. Herring that somehow the site constitutes a flyway, or not just a flyway, but the most important flyway for the bittern in the country. And we address that proposition at paragraphs 129 through 138. And it might be that this is a matter that we come back to after lunch, but in some respects, our submission in this regard really seeks to summarise and convey the key points identified both by Mr. Organ and by Mr. Gibson in response to those propositions. And no doubt this committee has had an opportunity or will have an opportunity to review the matters identified by those experts, in particular document 493 is prepared by Mr. Gibson and document 494 is prepared by Mr. Organ. That being the case, Madam Chair, it might be an appropriate time to break now for lunch. What we do next in the submission is respond to a particular reliance on the New Zealand flight height data that was central to the presentation given by Dr. Herring. Mr. Wright's done a bit of a deep dive into that material, and I'll be inviting Mr. Wright to address you on that topic after lunch. In terms of the balance of the submission, we're making reasonable time, and of course we'll finish today. I won't address every point that we've set out in writing, but just touch on a few matters that we think are important.
Yes, happy to break for lunch now. So we'll see everybody back at 2 o'clock. I'll keep it at 2 just in case there's anybody joining us online.
Thank you.
We'll see you shortly. you. Just before we get you to continue with your submissions, we've had one question come up that we'd just like to put now, and I'll hand you to Member Wilkinson to take you through that.
Yeah, Mr. Chair, so just a clarification around the sequencing of activities post-approval, assuming approval was granted. But go back to pages 16, 17, and if we use identified as an example, at the top of 17, it says that it can. Bottom of 16, it proposes a period of monitoring for about 12 months, and then at the top of page 17, it says it can then be used to inform turbine and camera placement. There's two sort of aspects here. There's design considerations, and then there's the operational considerations. And the key design consideration is the turbine placement. Operational considerations will be picked up in the VAMP about and how things are monitored and how it's run. Does the proponent? So I'm just wanting to understand the sequencing of activities from the proponent's perspective and how they see it. Will they see that this monitoring of 12 months would occur prior to a decision on turbine placement, or would that happen earlier?
Yes, I'm just turning to the incorporated document. And at page 9 of 15, at clause 7.20, you see here the implementation, if you like, of the measures that are proposed to be introduced. So the BAMP will require a number of things, including at D, the adoption and use of advanced technological identification for the purposes of completing pre-commissioning monitoring for the species of concern. And then at E, the adoption of the use of advanced technological identification for the purposes of identifying operational measures to manage impacts on species of concern, such as monitoring, detection or curtailment, unless certain things are demonstrated. And then at F, in determining the scope of application of identification, then a series of things would be considered. It's not contemplated that the monitoring regime would be a regime that was implemented and completed prior to the resolution of the location of turbines within the farm itself, that is the wind farm itself. Instead, it's contemplated that the monitoring regime would be implemented with a view to firstly, obtaining further data as to the nature and extent of flight patterns, but secondly, to identify the nature and extent of amelioration. And I suppose theoretically, were that monitoring program to be completed before the ultimate layout of the turbine array was determined, then it might influence it. But it's not contemplated that that be a requirement that occur prior to the array being finalised. Instead, it's contemplated that the monitoring would allow and inform assessments in respect of curtailment, more specifically than the positioning of particular turbines.
Yeah. Okay. Yeah, that's what I thought. I thought the position likely was. It was just that reference that you identified. I just want to clarify that. So, yeah, thanks for that.
That's a fair question in light of the way we frame that submission. Thank you. Okay, if we could return then to, I think we're at PDF page 38 of the submission, and I did indicate before the break that I'd invite Mr. Wright to address you on the part of our submission addressing the New Zealand flight height data. And just again, by way of context, we're focusing on this topic really as a means of demonstrating why it is that weight can't properly be attributed to the presentations that were given to you. That is why it's critically important to be able to test this material in order for it to be attributed weight in the nature of evidence or weight of a type that could properly stand against the body of evidence that you heard throughout the course of the hearing. And so it's really an example of the matters that one would need properly test and which we were not able to test as a consequence of the way that that material was delivered to the committee. So, Mr. Wright, I'll come to you.
Thank you, Mr. Chessel. So, members, as Mr. Chessel just indicated, the purpose is really to use this as a bit of a case study as to why we say the sort of approach that is the typical approach to assessment of technical matters like this is critical. And a second aspect of it is to demonstrate that, in fact, what is put forward by the Trust and other submitters, including BirdLife Australia, is a key piece of information about flight heights for the bitterns is entirely unreliable for the purposes for which it's been put forward in this proceeding through the submissions made by those submitters. To do that, what I'm going to take you through is, as expeditiously as I can, the material that's relied on is some documentation which is referred to in the submissions as Williams 2024 and Williams 2021, publications from a scientist in New Zealand, and then ultimately go through a decision made by a resource consent panel in New Zealand, which is the equivalent of this committee, that considered a wind farm in a part of New Zealand in which that material from Williams was in fact put. So that's the genesis of that material is the context of this proceeding, the same context as this proceeding. And so what I'd like to do first, if I can just take you in short form to how the material was presented by the Trust. And in document 420, which I'll put up on screen, you can see the particular part of the written submission that was made that in the two highlighted paragraphs refers to the New Zealand data. And it might be a bit too small for people to see on screen, but you can see in the first paragraph, 203 refers to 3 GPS tracked bitterns, and it provides a footnote 57, which is Williams 2024, which I'll come to shortly. And then reference to the birds flew within a rotor swept area 30 to 22, 220 metres, 59% for A. And that's the bird I'm going to focus on, which you can see in the graphs below has got tag number 4084. That's the bird that's said to have most frequently flown within a rotor swept height of between 30 metres and 220 metres above ground level. And then there's really an inference that's been sought for this committee to make, that is by extension, paragraph 204, the first of these birds, which is 4084, regularly flew within the proposed Kentbruck wind farm rotor swept area of 60 to 270. And then it says, notably, that bird flew in areas with variable topography, while the others flew in flat lowland areas, may explain the difference in flight height. And I'm going to come to the particular context that that's referring to in a moment. There was similar reference made in the presentation that was put in document 420. And then in the BirdLife presentation, the number of which I don't have to hand, it's not at the head of the document, but I'll give you the page reference. I'll bring that one up. It was PDF page 29 of the BirdLife Australia submission, where we can see the same 3 graphed images, but the bottom right corner you can see a reference to Williams 2021 as opposed to Williams 2024. So I'm going to take you to both of those documents, and then I'll take you. This is document 430. Thank you, Mr. Chester. So you can see that the submitters have sought to use this material to support an argument, at least by inference or analogy, that bitterns in this location might or will fly within the rotor swept height that's proposed for Kentbruck. Now, the matters that I'll take you to are the sorts of matters that we would have taken the presenters to in cross-examination to just give you an understanding of the approach we would have taken, really to fundamentally undercut the reliability of those propositions, which I'll do now. It's really to the point that a proper understanding of the context behind information like this is critical to proper understanding, and that context was not provided to you by the submitters who sought to rely on that information. Right. So what I'd like to take you to first is Williams 2024. Now, we haven't provided this document to you. We have extracted the relevant part of this document into our written submissions. If you're assisted by providing the document, we will file it afterwards. But really, all Williams 2024 does is refer to Williams 2021, which is the key document that you need to have an understanding of. So this is Williams 2024, and it's a departmental publication by Dr. Williams, and it's from the Department of Conservation. I should pause and perhaps give you some relevant context. If it's not apparent to you, I'm actually from New Zealand, so I have some familiarity with these agencies and the context in that country. It's a part of the country that I'm from. And so this is from the Department of Conservation, which is the equivalent effectively of DECA, or at least one part of DECA in Victoria. And this is a departmental publication that was produced by Dr. Williams, who no doubt has an expertise in the Australasian bittern, but it's not a peer-reviewed scientific paper. It has no more status than a document that's published by DECA here. It's not reviewed, it's simply a departmental publication. Now, the relevant page that the references to flight height are taken from is firstly page 24, and you can see there's a reference there to, and this is the paragraph we've extracted into our written submissions. And starting from, there is also evidence that the bittern could be at risk from larger infrastructures such as wind farms and tall transmission lines. Reference to height data collected from GPS tagged birds suggests the birds could be flying within turbine blade height for a high proportion of their flying time. A reference there is Williams 2021. Height profile data for these birds collected incidentally during a national landscape scale movement study were analysed in relation to a wind farm proposed in Northern Kaiwakawe wind farm. The proposed consent allowed blade heights between 30 and 220 metres above ground. A reference there to Turner 2021, I'll come back to. And then small sample size, but at least a reference to the one bird flying for 59% of the time within that 30 to 220 metre blade height. So that's why I've highlighted 59, and you can see that that's a reference to bird 4084. I'll come to that in a moment. And then further down this document, we find the same three graphed figures, which have been extracted and relied on by the Trust and BirdLife Australia, but no reference to what those graphs in fact show. So what I'd now like to take you to is Williams 2021, which is attachment 2 to our reply submissions. And as you can see, what that document in fact is not a study, it's not a scientific paper, it's a statement of evidence produced by Dr. Williams for purposes of the equivalent proceeding for the Kaiwakawe wind farm as we are in before you today. Now, it's a proceeding conducted before an independent panel, and I'll take you to who the panel was soon, and it's pursuant to an act which is effectively the equivalent of the Planning and Environment Act and or the EES Act in Victoria. So it's really the same sort of proceeding as we're in today. But what's critical about this document, which is, to be very clear, the genesis of this suggestion that the birds may fly within the rotor-swept flight height, is this statement of evidence. And you can see it was prepared by Dr. Williams. If I take you down to page 2, you can see Dr. Williams was at the time an employee of the Department of Conservation, paragraph 1.3. And then I'll take you, apologies, down through, you can see the scope of the evidence, which was dealing to the conservation status of Matuku is the local name for the bittern, threats and ecological requirements, the significance of the area where the wind farm was proposed, potential adverse effects, adequacy of information, and ultimately Dr. Williams' conclusions. And just pausing there, if I can summarise Dr. Williams' evidence, is she was unsatisfied by, very similarly to here, the extent of the survey effort, the adequacy of the survey effort, the assessment of various of the impacts on the species, and ultimately her conclusion was not enough was known about the species, the location, and the impacts of the wind farm in that location in order to proceed. So she was inviting the panel to refuse the consent, really on the same grounds that submitters have been putting to you today. Now, of course, in that case, that was evidence from Dr. Williams on behalf of the equivalent of DECA, which is the point of distinction to the case before you. I'll come to, when I come to the resource consent decision, what actually happened in respect of the DOC, the department's position, which did do a complete 180. But at this point in time, the evidence was you shouldn't approve because we don't know enough, and you don't know enough about impacts. Now, on page 12, we find a reference to, page 11 first. This is under a section headed Mobility and Flight Class of the Matuku. Reference is highlighted in that paragraph to figure 3, illustrating an 18-month track of movements for one of the birds that was tracked with a GSM tag, which is what follows in that paragraph, a description of a tag that continuously tracks the birds and downloads the points via a cell phone tower network. And you can see, if I highlight it on screen, it's a reference to the bird being caught at a lake near Ohalpa, which is in the Waikato municipal region, but travelled periodically to the Bay of Plenty, which is another municipal region that I'll show you in a moment. And then over the page, figure 3 shows us the tracked movements for, and you can see and highlight, bird number 4084. So that's why we're focusing on that particular bird. And the green is the flight paths. And if I explain to you, on the right-hand side of that image is the Bay of Plenty area. And on the left-hand side of the image is the Waikato region. And what will become important in a moment, I'm not sure if you can see my cursor on screen. I'll try to make it a little hand. Can you see the hand there, Madam Chair?
Yes.
I'll move it around. Where the cursor's moving now is a mountain range which separates the Bay of Plenty from the Waikato regions. And that's the height, that's the terrain that the bird was flying across when it was being tracked, at least in part. Now, next, if we go forward in the document to page 31, you can see a summary of the heights or assertions made by Dr. Williams about the height. And you can see reference there to a Mr. Fuller at the start of that paragraph. That was the avifauna expert called by the proponent in that case. And then in the highlight, you can see reference to, although I have only small sample sizes, 3 birds, the data so far indicate that some birds may fly within the turbine height proposed at the wind farm most of the time, but this varies and most likely with the topography of the habitat. For example, tag 4084, a bird that frequented mixed hill and coastal topographies, similar in many ways to the wind farm project area. Data for this bird consists of 3,581 flight height measurements over 18 months. Of these, mean height was 78 metres above ground. Total of 89% of height observations were within 330 and 220 metres, which is the blade height span indicated for the proposed turbines. The other 2 cross flat landscapes. There's a couple of things just to provide you proper context about these figures, which I'll come to in a moment. And if we move down to figure 12, we see in the middle of that paragraph the reference to the same bird, 4084, being tracked across mixed topography hill country in the Waikato and Bay of Plenty. And this is where we find the 3 graphs that have been later extracted into Williams 2024 and then relied on for purposes of the submissions made by the Trust and BirdLife Australia. So there's a bit of context I need to provide for you here. The first thing is the graphs. Now, what's being shown is not tracking of birds at the proposed wind farm location. It's, by analogy, tracking from a different part of the country, which I'll take you to shortly, overlaid with the red box, which is the proposed rotor-swept height for the wind farm in an entirely different part of the North Island. So it's not the location of concern before that is the subject matter of the statement of evidence. It's an analogy that Dr. Williams is drawing purely based on flight height and rotor-swept height in a different location. Now, for someone like me, that's an immediate red flag as to the reliability of information like that, where what you're doing is solely relying on information by analogy with no particular survey height of the birds in the location at which the wind farm is proposed. So that's sort of red flag number 2. Red flag number 1 was the fact that Williams 2021 is a statement of evidence, not a scientific paper. So to the extent that you can't rely on Williams 2021, you can't rely on Williams 2024 because the only reason or basis given for flight height assertions in Williams 2024 is this statement of evidence. So the first falls, the second falls, and if that falls, the whole house of cards falls and can't be relied on. So red flag number one is the fact it's a statement of evidence, and I'll come to why it's unreliable, because ultimately it was not accepted evidence. And secondly, red flag number two is the fact that the graphs, which are being relied upon to join the dots between a wind farm and tracking heights, is by analogy only, not by reference to the particular location in question. So that's a problematic approach, full stop. I'll just very briefly refer to what follows as a reference at that paragraph below and highlight on screen to the use of ridgelines and saddles. And Mr. Fuller, the proponent's expert, was suggesting that Matuku, the birds do not fly across ridgelines but follow saddles. And Dr. Williams disagreed and said her tracking data indicated this particular bird would fly over the ridgeline. And I'll come to the ridgeline in a moment. The reason I raise that will become apparent when I take you to the consent decision, but you might recall Mr. Organ's evidence by reference to the fact that the birds would follow gullies as opposed to potentially following ridgelines, which goes to the height at which the birds may fly. Now, that'll become apparent in a moment when I take you to the decision why that's relevant. And then finally, at the back end of this document, we find the conclusions that are being drawn by Dr. Williams, and I've just highlighted the final paragraph, which encapsulates the reasons really why Dr. Williams was saying you couldn't proceed with the consent, which is because of the proponent's approach to evaluating the bird, there are considerable uncertainties about use of the site by Matuku. The applicant has not accounted for the potentially high flight rates that are likely to occur over the site based on my research findings and similar habitat mosaics. Considerably more work will be necessary to understand the wider impacts on the birds and the habitats. Therefore, in my view, we do not know enough to discuss the potential for offsetting in relation to impacts on Matuku or changes to design of the project that might be considered before a final decision is made. Further monitoring using the correct methodologies is needed so that the potential adverse effects on Matuku can be properly assessed. I.e., we don't know enough, you can't fix it with further monitoring conditions, so you should say no. That's what the approach was being posited by Dr. Williams. Now, I'll take you to the consent decision, and that's attachment 4 to the package we've provided to you. And you can see it'll be in a format that'll be very familiar to this committee. It's the same sort of thing that we experience in this jurisdiction. And you can see at the beginning that it's, in fact, the consent was granted by the panel. And it sets out its reasons. The hearing panel was comprised of 3 people: Mr. Hill, who's a town planner, Mr. Panya, who was a barrister at the time, now an Environment Court judge, and a Ms. Varys Woodstock, who was a councillor of the local council, the Kentbruck Council. And you can see who was being called by the applicant, which included Mr. Fuller for ecology and a Mr. Turner for planning. And then you can see for the Department of Conservation, Dr. Williams was called about the bittern. I take you forward to paragraph 7 of that document. You can see highlighted on screen that the department's position was originally strongly opposed to the grant of consent, including adverse effects on bats and bittern, with the case essentially being there was insufficient information or evidence before the panel to make a decision. However, that changed later on. You can see recorded at paragraph 9, there's a reference to a memorandum of council, which records in the middle of that paragraph, extracted that DOC has amended its position and is no longer in opposition to the grant of resource consent, notwithstanding Dr. Williams' evidence. And there was agreement reached on changes to the condition set, and ultimately that permission should be granted subject to conditions. And I'll come to the conditions in due course. Now, paragraph 48, I'll just take you to very briefly, references to Dr. Bennett from an avifauna expert was called by the local council, which supported the position and opinions of Mr. Fuller, the proponent's avifauna expert, with respect to potential effects on Matuku. And she agreed with Mr. Fuller rather than Dr. Williams and said that consent should be granted. Then paragraph 70 to 72, we find the panel's description of the evidence that was given by Dr. Williams, expert on Matuku, discussed the conservation status, threats and ecological requirements, etc. Problems with putting a wind farm in that location. And then reference to, in 71, collisions with turbines were potentially an additional threat. It was Dr. Williams' opinion that the area and site was a stronghold for Matuku and the death of one bird was unacceptable and could be catastrophic to the population in the area. Reference to supplementary evidence, which I haven't been able to find, which is you shouldn't put them here effectively. And then ultimately, it would be very unwise to introduce a new threat of an unknown magnitude to a stronghold site of a critically endangered species. Such an additional threat would be in place for a long period of time at a time when national recovery methods for the species are still in their infancy. So this is very, very strongly worded evidence from an expert about the impacts on the bittern at that particular location, which is very similar to the sorts of evidence, or rather submissions, that have been put to you by the Trust and other submitters. I think there might be a lag between the screen. But paragraph 73 is a reference again to DOC. Whilst it maintained its concerns about Matuku, it accepted that conditions of consent can appropriately manage any potential adverse effects on the bird. Then we find, starting at paragraph 77 and later, what I'll express as very strong misgivings expressed by the panel about the evidence given by Dr. Williams and another expert, Ms. Burns, which primarily related, but not exclusively, to the fact that neither of those experts had undertaken a site visit to the wind farm location prior to expressing their opinions. I'm going to pause there. I said I was going to take you to some more particular context about the location, and I'll do that by reference to two things. Firstly, I'll take you to Google Earth. Zoom out and show you the North Island. Hopefully. Sorry, there's a bit of a lag between the screens. So that's the North Island of New Zealand. Where bird 4084 was tracked is from a location that's around about where the little hand is, next to Hamilton, which I'll zoom in on. This is the Waikato region, and it was flying across to Bay of Plenty region, which is indicated where the little yellow pin is. Now, those two regions are divided by a mountain range called the Kaimai Range, which is the north-south green extent that you can see my cursor running down now. I'm going to come back to that in a moment. Where the wind farm was, or is rather, it's under construction now, is much, much further north at a location close to Dargaville in this part of the Kaipara Council area. Now, I'm not seeking to make anything of the distance. The distance is about 300 to 400 kilometres, which is not without bounds of bitterns flying to, but the bird in particular that was tracked over 18 months never went from the Waihi area across to the Dargaville area. It was only ever tracked flying from the Bay of Plenty across the Kaipara Range to Hamilton, or rather the Hamilton area. Now, the Kaipara Range is described in the submissions and the Williams 2021 and 2024 material as hilly terrain that dramatically understates what the Kaimai Range is. It's in fact more properly described as a volcanic mountain range. And I'm not going to make anything of the images I'm about to show you because there's many different images of the Kaimai Range that can be shown, but I'm going to pull up, if one Googles Kaimai Range and you pull up the images tab, and I'll just zoom in on one side of that screen. And you can see the very steep escarpment that is the volcanic Kaimai Range that extends to about 1,000 metres above sea level. The point I'm seeking to make is it is entirely different topography from anything around the project area for Kentbruck or anything between the Long Swamp area and the Riverina area. Now, all I can make of that is one might make an inference that there could potentially be different behaviours between the bird that's habituated to fly between and over the Kaimai Range and the birds that are habituated to use and fly around the Kentbruck and Riverina areas, in context of this bird in particular never going elsewhere in the 18-month period other than between those two locations or around that area. So it's a, if you like, a third red flag to reliance on the material that Dr. Williams is seeking to use by analogy for that purpose in the wind farm case in New Zealand. So it's just fundamentally different context. Now, I'll come back to the consent decision. And paragraphs 81 and on, you can see description of Dr. Williams. So there's about a 2-minute lag, it seems, between the screen and the screen, so I'll just build. All right. Paragraph 81, Dr. Williams had categorical opinions on the effects of the wind farm on Matuku. She maintained these opinions throughout the hearing, and ultimately we did not accept her opinions compared to those of Mr. Fuller, who was the proponent's expert. This was in part due to her not having been onto the site and therefore not being able to give a site-specific assessment of the topography, including ridges and saddles. Mr. Fuller's opinion being that if Matuku do fly across the project envelope, they'll be much more likely to fly over the saddle when those turbines were to be located than the ridges. That's the reason I took you to the part of your evidence that referred to them flying over the ridges, because ultimately for this particular location, despite that evidence, it was not accepted by the panel, which preferred the evidence of the proponent's expert, that they would be more likely to fly over saddles rather than ridges. Now, not much can be made of that except the saddle is lower in the elevation than the ridge is. And so that's evidence that was accepted by the panel that the birds are likely to fly in that location at lower elevations than the ridge line. I don't seek to make any more of it than that. Then we find the strong condemnation of giving evidence without having undertaken a detailed site visit, which is not consistent with what is expected of expert witnesses. And then, given the above, noting Mr. Fuller's significant experience in assessing the impact of wind farms, we have greater confidence in his evidence compared to Dr. Williams and place greater weight on Mr. Fuller's evidence. If I take you forward to paragraph 173. Eventually. At 173, the panel said, having regard to all of the above, we turned our minds to the question, are the adverse effects on Matuku avoided, remedied or mitigated such that they are no more than minor, which is effectively the same question that's before this committee in respect of that and other species. And then at 174, in relation to this matter, we had extensive evidence from Mr. Fuller, including his evidence in chief, rebuttal and supplementary evidence, and Drs. Williams and Burns, which we have set out. As we've already set out, we've placed greater weight on Mr. Fuller's evidence than that of Dr. Williams. This position was reinforced. Having read and heard Mr. Fuller's supplementary evidence, we discussed additional monitoring undertaken, which he had peer reviewed, both internal to his organisation and externally. The reason I paused and have highlighted that is that what you have before you is evidence from the biosis team, which undertook the primary work, and you have independent peer review by Mr. Organ, which supports the outcomes, although in respect of the return, of course, Mr. Organ says no significant impact. Then we're almost at the end of this document. Paragraph 181 and 182, panel records, with respect to the ecological effects, it was Mr. Turner's opinion, Mr. Turner was the proponent's town planner, opinion that the project envelope approach and no turbine area overlays would result in the avoidance of the number of effects in the first instance. He also opined, relying on the evidence of Mr. Fuller, that any potential effects, including on Matuku, could be avoided, remedied or mitigated by the issues set out above, the design of the wind farm, but also by conditions offered by the applicant, including those relating to Matuku. He supported those conditions. Mr Turner also confirmed at the reconvened hearing, COVID interrupted the hearing, that the results of the additional baseline survey, the validation of the band model, wetland enhancements and the Bittern Management Fund, which I'll come to, those two, reinforced his planning view that these would ensure any adverse effects, including on the Matuku, would be no more than minor. He also considered that the wetland enhancements and the Bittern Management Fund would likely have positive environmental effects. And then finally, in respect of the Bittern, at paragraph 189, as Mr Fuller has stated, he is confident that the impact on the Matuku can be managed such that the risk to them is very low. We agree with him based on the evidence before us. It is our view, and that expressed by Mr Welsh in his reply submissions, that to exclude wind farm, who is the proponent's legal counsel, to exclude wind farm development from large parts of Northland simply because Matuku are also present in the region is not a scientific approach to ecological impact assessment, is not supported by the statutory policy framework, and would not now, as we address below, give effect to Part 2 of the Resource Management Act. Moreover, we are satisfied any adverse effects could be avoided, remedied or mitigated such that they were no more than minor. What you won't find anywhere in this document is reference to acceptance of or reliance on Dr Williams' evidence about flight heights and the analogy between flight height tracking data and the rotoswept area of that proposed wind farm. Clearly, in my submission, that the panel did not consider that evidence to be sufficiently important to make any finding or recording about it in the decision, notwithstanding that it was evidence purported to be that the birds would or may fly within the rotoswept height of that wind farm. And of course, that's the only element that the submitters in this case are seeking to place weight on, to draw an analogy between the flight heights recorded for that one bird in that entirely different part of the country in an entirely different topographical context, to say that the birds at Kentbruck may or would fly within the rotoswept height of what's proposed by the proponent. So that evidence was not accepted in the context in which it was given in the case in New Zealand. It should not be consequently given any weight, we'd say, in this proceeding. The final thing I would like to take you to briefly is the consent itself, which is available online. We've provided a copy to the committee. The consent is like a permit, effectively, and what it provides is, I won't take you to in any detail, but I'm just going to draw an analogy. You'll find from page 19 of the document a series of detailed conditions specifically directed to the Matuku, and that includes things like baseline surveys, monitoring requirements, a monitoring and management plan, which one might say is the equivalent of the BAMP. You will see requirements for further survey reporting of baseline surveys, and then you'll see construction and post-construction survey reporting, all which is required by the BAMP. You'll then find requirements for bird mortality investigations, another feature that's of the mitigation measures before you. You'll find further surveys of road management measures. You'll find a requirement for an Australasian Bittern Management Fund, which was in the amount ultimately of 640,000 New Zealand dollars for the purpose of providing investment for initiatives and programs by DOC or iwi. Iwi is the term for Māori tribes in the locality that promote the protection or enhancement of the population of the bittern. Draw the analogy to the ecology fund that's proposed before you here, much greater number, but and much greater number. Of course, bittern would be only one of the species that funds could be directed to. Then you'll find some further bird collision monitoring plan requirements and collision monitoring requirements before the consent turns to other matters. So all we would invite this committee to do, not seeking you to place any weight, of course, on the decision that was made in respect of the wind farm in New Zealand, but we invite you to firstly note that the key piece of information that submitters here are seeking to rely on to draw an analogy to heights for birds around Kentbruck came out of a piece of evidence that was not accepted by the panel before that evidence was presented, did not result in a refusal, notwithstanding inadequacies in the analogy, but much more direct relevance in that case than it has here, where it has no relevance whatsoever. And ultimately, the panel was seized of the evidence that Dr. Williams gave about her concerns about the survey effort, monitoring effort, understanding of the birds within the location of the wind farm, the impacts of the wind farm on those birds, and the adequacy of conditions that were proposed by the proponent. The panel rejected all of that and concluded that the impacts on that bird, of the species in that location, by reference to conditions that are very, very similar to those that are before you, that those impacts were minor and acceptable. So Dr. Williams' evidence in that regard was rejected. So those are the sorts of matters that would have come out, we say, if we had had the opportunity to cross-examine Dr. Herring and the BirdLife Australia presenter in respect of their reliance on that material. And suggest, Madam Chair, that it would have been apparent that the material is in fact entirely unreliable for the purpose for which it was put to you. Thank you, Mr. Chisholm.
Thank you. Members of the committee, it's of course the case that there is flight height data in respect of Australasian bittern, including measurements, as we understand it, undertaken in and around the subject site. And you recall that before we were aware that Dr. Herring was making a presentation to the committee, we'd indicated to you in the context of the ecological evidence that we, being my instructor, had sought to engage with Dr. Herring to obtain that data, that is the data in respect of the flight height associated with Robbie. But separately, Biosis and Mr. Organ had reached out to Dr. Herring to obtain that information. And the response that we received from Dr. Herring was that the data was still being analysed. And you'll recall that when Dr. Herring did make a presentation to the committee, he explained that, well, he hasn't released that because it hasn't been fully analysed yet, and that it would need to be further analysed in anticipation of publication in an academic journal. But it is disappointing in our submission that that data wasn't released. And we say that because Dr. Herring has had that data for almost 10 years. I mean, these measurements are not recent measurements. They were, I think it was 9 years ago that the measurements were undertaken. And that data has still not been published, hasn't been released. And frankly, had we known that Dr. Herring was actively involved as drafting part of the submission on the part of the Trust, we would have called for a direction from the committee that it be released so that we could analyse it. And it points in our submission to the absence of a proper evidentiary basis to support the assertions, and that's all they are, assertions advanced by the Trust in respect of the impact of the project on that species. Now, I'm mindful of the time and I'm keen to move through the submission. I'd like to pick up again, please, at PDF page 43, where we address the assertions about the expertise of the presenters on behalf of the Trust. I feel we've addressed that issue sufficiently. At paragraph 160, though, we do make some observations about the presentation given by Mr. Buckman, particularly in respect of the capacity for restoration projects to be implemented in and around the site. The tenor of that evidence was that those types of exercises are difficult, and it seemed to us a proposition that they were unlikely to be able to be achieved by others. And we don't take issue with the proposition that restoration projects of this type present challenges. But what we do take issue with is the proposition that a proponent dedicating funds pursuant to a robust EMF could not achieve comparable outcomes in respect of other nearby sites. And in our submission, quite to the contrary of the submission advanced by the Trust, what the committee should accept is that a well-resourced, well-planned, well-implemented series of measures can achieve successful restoration projects in and around the Long Swamp complex, including on sites such as Block 7, which has been identified as a potential offset site should that be considered necessary by the committee and ultimately the Minister. Before I move to the next topic, I note that Dr. Bennett made submissions by way of a video presentation, and as a consequence it wasn't possible for even the committee to seek any clarification as to the matters addressed by that presenter. What we would say about that presentation is that it was wholly a series of assertions that lacked, again, an evidentiary basis. What we note more particularly, though, is that the presenter made no reference to the materials that have been submitted, particularly in respect of this project. No reference, for example, to the symbolics report that was prepared to address the proper means by which mortality monitoring could be given effect in a plantation setting. No reference whatsoever to the BAMP that is proposed to be implemented in respect of this project. And indeed, one of the propositions advanced by that submitter was that we should be pushing for between 95 and 99% protection for southern bent-winged bat. But the point that we make in response is that the best evidence is that this project would far exceed those thresholds on the basis that the vast majority of movements in it, that is more than 99% of southern bent-winged bat movements, would be below the rotor-swept height of these turbines. And so again, it's demonstrative of the types of matters that would need be explored and tested were the committee to attribute those types of submissions material weight. I'm now back at the written submission at PDF page 44. We make reference to the responses prepared by Mr Organ and Mr Gibson to the queries raised by the committee. We rely upon those materials. And then at paragraphs 166 through 171, we set out a response to the submissions advanced by BirdLife Southeast, South Australia, BirdLife Australia, and by Mr Tuck. And there's really 2 points we wish to address here. The first is that in many respects, the weight that the committee can properly attribute those submissions need be viewed through the same lens as the weight that the committee can attribute to the submissions made by the trust. That is because, again, to the extent that those submitters sought to advance submissions of a technical nature in regard to matters within their professed expertise, there's no opportunity to test or validate those opinions in the normal way. The second point we make is that you have before you now responses to some of the matters raised, prepared by Mr Gibson and Mr Organ. We note, for example, that at paragraph 170 of the submission, we refer to the contention made by Mr Tuck that there is a wetland situated toward the northwest portion of the project area. We note that Mr Organ explained in his response that this area was not mapped by DECA and that it does not function as a wetland on a permanent basis. Mr Organ went on to explain that even if that area was considered suitable habitat for wetland bird species, the turbines in that location are set back by more than 1 kilometre from that area, such that any potential impact is properly ameliorated. Mr Gibson also addresses this particular issue in his response. He indicates that he went out and physically inspected that area. When he inspected that area, it was not in a condition of a wetland, but makes similar observations to Mr Organ about potential impact. I note that just while we're on this topic, Mr Gibson's response document, which is document number 490, contains responses to a number of the other propositions advanced by these submitters, and in particular by Mr Tuck. For example, you recall that BirdLife Southeast South Australia and Mr Tuck pointed to the presence of stringy bark to the south of the site in the context of potential impacts on the cockatoo. And what Mr Gibson explains in his response document, this is document 490 at entry 37, is that when one turns to the EES, you see modelled stringy bark habitat distribution sourced from the recovery plan that does show some stringy bark habitat south of the project area. But as Mr Gibson explains, that area is highly restricted and likely limited to a small few locations. Furthermore, there are several public access points visited regularly by the public, and the paucity of records for that species in those areas suggests the species rarely occurs there. You recall that I think it was Mr Tuck made submissions about the potential impact of the proposal on wedge-tailed eagles. And Mr Gibson notes in his response to item 16 that the EES itself at Appendix C provides a detailed consideration of potential impact to that species, including by means of a collision risk modelling assessment based on site-specific observation data. So, again, the points we wish to make in response are that engaging properly in the EES materials demonstrates that each of these matters that have been raised are matters that have been properly considered and demonstrated to be acceptable in the context of a project of this type. Now, the next part of the submission responds to the 3 submissions that were directed very clearly toward the assessment undertaken in respect of the Brolga, and that, of course, is the submission of Mr Cumming, Ms Lenihan and Ms Dennis. I'm happy to proceed on the basis that that part of the written submission is read, and I'll just emphasise 2 matters for present purposes. There's really, as I said, 2 things we wanted to emphasise from the written submission that we've set out. The first is that, for the most part, the submissions by these submitters were largely not directed to this project. That is to say, they were instead principally an attack on the scientific basis that underpinned the specification and calculation of buffers formulated in respect of the project, that is, on the Beltime work. And in that sense, they're submissions that are properly characterised as a generic attack on that scientific understanding, as opposed to a specific attack on this particular project, though of course they oppose the application of that science to the formulation of buffers for this project. The point that we really wish to make is that there was no suggestion, for example, that there'd been any failure to address a particular feature of the locality of this wind farm. That is, there was no suggestion ultimately that there was a breeding site that had been ignored or a flocking site that had been ignored. You recall there had been some suggestion about Oxbow Lake earlier in the hearing, but that proposition wasn't advanced through submissions. And in our submission, that's significant. That is, whilst there was some contest to the adequacy of the surveys that have been undertaken by the proponent and by Biosis, there is no proper basis for this committee to form a view that somehow we've missed some vital piece of information about Brolga habits in and around the subject site. Instead, the primary focus of the submissions were issues that those submitters had with the scientific analysis undertaken by Veltheim. In our submission, we rely upon the evidence given by Mr Van Oster and by Mr Organ as to why it is that Veltheim constitutes the best scientific evidence. It is peer-reviewed. It is academic material that is published in an academic publication. And furthermore, it is material that has been endorsed by the state as being appropriately utilised for these purposes. And it is significant, or it should be significant in our submission to the committee, that as recently as a number of months ago, the state, in issuing the updated handbook, has issued a very clear endorsement of the approach that was utilised in this instance by reference to the Veltheim material. That is, to the extent that it is quite explicitly called up for application under the new handbook. And you'll recall perhaps that in our closing submission, we made the observation that even if you took the submissions from Mr Cumming, Ms Lenihan and Ms Dennis at their highest, what would be required would be further assessment in respect of the impact. That further assessment would be required to be undertaken pursuant to the terms of the new handbook, which unambiguously call or direct the application of the very same approach that was adopted in respect of this proposal. You recall that there was some, what I'll characterise as a weak suggestion from Mr Cumming about a potential legal challenge to the handbook, but nothing has materialised, and of course the committee is entitled to proceed on the basis that the recently issued handbook stands on its terms and that the manner in which that handbook endorses and gives explicit effect to the scientific analysis within Veltime is relevant and does bolster the approach that's been adopted here. But in our submission, the committee should not take the submissions of Mr Cumming, Ms Lenihan and Ms Dennis at their highest. Instead, when the committee comes to review the Veltime material, I'm sure it's already done it already, what one sees is a sophisticated and nuanced approach taken to the analysis of breeding habits of Brolga, particularly in the context of informing the preparation of buffers. That is, when one reads Veltime 2019, one sees explicit reference to the purpose of that scientific analysis being to inform the specification of buffers within southwestern Victoria for projects of this type. That is, it's not just the best evidence available to date, it is the best evidence that is available that concerns this very issue, that is the appropriate formulation of buffers to protect breeding sites for this particular species. The second matter that we wish to emphasise about these submissions is that there simply is no evidence of Victorian wind farms in southwest Victoria, that is, wind farms in southwest Victoria, giving rise to direct impacts on Brolga. As we understand it, there is a single record of mortality for this species across all wind farms. And it's perhaps for this reason, that is the absence of evidence of direct impact, that so much of the focus of the submissions was on indirect impact, that is on displacement. And considerable effort was spent during the course of those submissions seeking to establish displacement based on a comparison of pre and post monitoring reports completed for different wind farms across Victoria. And we really wanted to say two things in response to those submissions. The first is a substantive response. That is, we rely upon the response prepared by Mr Organ to those materials that were circulated in advance of cross-examination. And you recall that after Mr Organ completed his evidence, he was asked to prepare a document that set out that material. He did so, and in our submission, that very careful analysis of what's shown in the pre-construction records and the post-construction records makes good the proposition that one can't rely upon them to establish displacement in the way that the submitters sought to do so. But secondly, we note that the committee sought advice from and received a response from DECA in respect of this very question, and DECA's response was that there was simply no evidence of displacement and that both the handbook and the interim guidelines explicitly address indirect disturbance, which includes displacement, in the manner that we've already described, that is by providing the additional 300 metre buffer that's been provided in this instance to address not just direct impacts but indirect impacts, including displacement. And so in our submission, much of the attack on the scientific literature seemed to be misplaced, but more fundamentally, this committee is entitled to proceed on the basis of the evidence that you've heard before you as to the proper status of the Veltime work and upon the response provided by DECA as to how it should properly be applied in respect of an application of this type. And so they're the matters that we wish to emphasise in respect of that part of our written submission. That brings us then to PDF page 50, in the bottom of PDF page 50, where we set out a response to the fourth category of submissions that we identified at the outset, that is our response to all of the other submissions. And we note that, as an opening observation, that many of the submitters professed their support for renewable energy projects, but argued that this particular site was inappropriate. And the submitters raised a number of matters in support of their propositions, but it seemed to me, at least, having heard the entirety of their submissions, that the key issues that were raised were ecological impacts and landscape impacts, amongst others. And Of course, these are matters that the committee will need to carefully consider. In our submission, though, it must do so objectively, and it must do so having regard to the applicable legislative context. And as we were at pains to identify at the outset of this case, in opening our case, an important part of that legislative context is the very clear and ambitious targets that have been established in respect of greenhouse gas emissions and the transformation of the electricity network. And as we identified, it's important that the committee be cognisant of the scale of change anticipated and the timelines within which that is to occur. And so, whilst it is the case that a number of submitters identified factors that they said should discount this site as being an appropriate one, in our submission, none properly engaged with the applicable legislative settings that do apply, and recognised that, importantly, there will inevitably be trade-offs, regardless of where facilities of this type are situated. And in our submission, the committee should fundamentally reject any proposition, a proposition that was in fact advanced on numerous occasions, that somehow this location is fundamentally inappropriate for a facility of this type. It's simply not identified as such within the planning scheme, nor does a detailed analysis of the particular impacts of this proposal demonstrate that that is the case. And so at 199, we observed that while it is understandable that some members of the community are concerned about the nature and extent of change envisaged by the project, in our submission, that extent of change is an inevitable consequence of realising the vision called for by state and federal policy. And we do say that it's telling that no party before you led any evidence or made any submissions that challenged the series of fundamental propositions that underpinned Mr Bolt's evidence. And I appreciate we've been going 8 weeks in this hearing, but if the committee goes back in time 8 weeks and thinks about the first day of the hearing and the series of propositions that Mr Bolt advanced that demonstrated why it is this proposal responds so favourably to the applicable settings, in our submission, that is critical context to bear in mind when the committee comes to consider objectively the various matters raised against the project by the submitters. Now, before I move on to the Save Our Surroundings submission, I do note that at various points in the submission, certain straw man arguments were advanced. I think it was Mr Meredith that made a submission to the effect that at some point in time we would suggest that the submitters were advancing a NIMBY case. And we're not running that case at all. We're not suggesting that the submitters should be characterised as NIMBYs. What we do submit, though, is that when this committee comes to consider these issues, it must properly grapple with the applicable legislative contexts that include those very clear and ambitious targets that call for many of these types of facilities to be delivered in the short term within this state. And when one considers those submissions in the context of this part of the state with its particular wind resource and its particular attributes that we identified on the first day of the hearing, it points very clearly in our submission to this site possessing a number of attributes that make it very suitable for this type of proposal, and those need to be considered properly as part of the exercise, the evaluative exercise of this committee. Now, there's a submission made by Save Our Surroundings Riverina. We address that in the next part of our submission. I'm going to be very brief here. I'm going to be very brief because the written submission by that submitter was very difficult to follow. It was really just a series of dot points that didn't set out any clear narrative or proposition in respect of the proposal. Instead, we had the rather unusual circumstance of the submitter choosing not to turn up, but instead having their witnesses turn up. And what we say about those witnesses is set out in this section of the witness statement. At paragraph 204, we observed that Mr Kennedy, whilst no doubt possessing certain qualifications relevant to the matters that he addressed, really advanced hypotheses in respect of what we would describe as new science. That is, the proposition or the hypothesis about the heating effects of wake effects attributable to turbines is just that, a hypothesis. It hasn't been tested. It's not required to be tested under any legislative framework that we're aware of. It hasn't been tested in respect of any wind farm project that we're aware of, and in our submission doesn't require assessment in this instance. The second hypothesis was the hypothesis concerning ocean calcification and the extent to which that might be contributing to greenhouse gas emissions. That's got nothing to do whatsoever with this project and needn't be a matter that the committee gives any consideration to. Let's hope that Mr Kennedy's not correct in his hypothesis that ocean calcification is materially contributing to greenhouse gas emissions, because if it is, we're all in trouble, but it's not a matter that this committee need concern itself with. At 205, we addressed the evidence given by Mr Piper. Mr Piper, in our submission, did not hold the relevant qualifications to give, or expertise to give evidence about the impact of the facility on aerial firefighting. Of course, his position stands in contrast to that given by Mr Jennings, by Mr Taylor and by the CFA, and can't be given weight. Furthermore, we note that Mr Piper was a self-confessed climate denier whose independence really must be questioned by the committee. Then at paragraph 209, we addressed the evidence given by Mr Morrison. In my submission, that evidence was somewhat curious, again, to the extent that it just seemed not to be directed to this particular project, but instead to be the expression of views that Mr Morrison holds in opposition to policies enacted by the state and federal government in relation to emissions reductions and the transition in the renewable energy generation market. And furthermore, some high-level opposition to the ISP as issued by AEMO, and an assertion, and nothing more than an assertion, that ISP perpetuates false and misleading information about the benefits of the transition to renewable energy and, in particular, the implications on the price of electricity. Again, our submission is the committee need not concern itself with these matters because the committee is entitled, and indeed must, have regard to the established position of the federal and state governments in respect of greenhouse gas emissions and the transition in the electricity market, and is entitled to, as is the proponent, read the ISP at face value as it concerns the specified path toward the transition in the electricity market that is required in order to achieve the relevant state and federal objectives. The next part of the submission at PDF page 55 sets out a response to the Victoria National Parks Association submission. And the one aspect of this submission that I wanted to focus on is what the matter set out in subparagraph A. And in essence, the association contended that the location of this project in proximity to the national and coastal parks discounted or disqualified this site as being an appropriate location. But the point that we would make in response, and a point that really was not properly addressed in our submission by the association or by those other submissions that made these high-level claims about the locational attributes of the project, is that they just failed to recognise that the site here is within a commercial pine plantation, farming zone land, agricultural land. It has limited ecological value, not no ecological value, but relatively little ecological value compared to those areas to the north and to the south, and is demonstrated objectively by the assessment recorded within the EES and by the independent expert evidence. In our submission, the locational attributes of the project are clear. That is, it is an appropriate location for a variety of reasons, and furthermore, the impacts of the project, the indirect impacts on the areas of higher ecological value to the north and south, are capable of appropriate mitigation and management through the regime that's been proposed. At the bottom of page 56, we make reference to the submission made by the Committee for Portland. The committee was largely supportive of the project, And what we do at paragraph 216 is respond to the particular matters raised in respect of traffic, the local procurement of workers and services, and across the page, at the bottom of the page, the local content requirements that apply. We're happy for those parts of the submission to be taken as read. We next turn then to the submission of Mr Turner, and before I turn to the specifics of that submission, I would like to give credit to Mr Turner, credit for actively participating in this process throughout, and credit to Mr Turner, who undoubtedly has an eye for detail. Indeed, it seemed to me, listening to Mr Turner's submission, that because Mr Turner did actively engage in the hearing process, he presented what ultimately was a more nuanced position than many of the other submitters. That is, unlike any of the other submitters opposed to the project, Mr Turner identified certain modifications that he said should be implemented in respect of the project rather than simply advancing a wholesale opposition to it. Now, we disagree with those modifications, but they included, for example, removing turbines from the SLO area. We've addressed you why we say properly construed, having regard to the terms of that control. That isn't an appropriate outcome in planning terms. Mr Turner called for, I think it was 3 turbines on the northern part of the array to be removed to facilitate a notional corridor for cockatoo movements. We say that hasn't been borne out by the evidence. And Mr Turner called also for some unspecified further buffer from wetlands, as I understand it, in respect of broker movements. And again, we say that hasn't been borne out by the evidence. But what we do say is that Mr Turner did actively participate in the process, and perhaps because of that, he was able to advance what was a more nuanced position than many of the other submitters. What we do in our written document is respond to the particular matters raised by Mr Turner, starting with Boiler Swamp Road and the various submissions made by Mr Turner in that regard. And the key points are really the matters we've set out at paragraph 218 and 219. And with respect to the submitter, we suggest that many of the matters that were of concern to Mr Turner stemmed from a failure to appreciate the distinction between the project approvals phase, that is this phase of the project, and the detailed design phase that will follow. And the resolution of many of the specific design and construction details that Mr Turner addressed in his submission are matters that are appropriately and ordinarily resolved at the detailed design stage. And what the committee need be satisfied of and should be satisfied of is that an appropriate framework is in place to ensure that those matters are considered. Now, at 219, we say furthermore that the committee need be satisfied that it has sufficient detail before it to allow an assessment to occur. And in our submission, you have that information. Indeed, you have a particularly conservative assessment of impact, particularly in respect of that aspect of the project. Now, over the page, Mr Turner made submissions in respect of the options assessment, in respect of decommissioning, and in respect of the Glenelg River. We content to rely on our written submissions there. Perhaps just to note again that in his submission, Mr Turner sought to rely on the terms of the Heritage Rivers Act in support of his propositions, but as we sought to explain in our closing submission, the terms of that act are not operable in this context. No permission is required pursuant to that act. Nor is there any proper basis to conclude that the project would unacceptably impact upon the river, even if the provisions of that act were operable. At paragraph 230, we respond to Mr Turner's contentions that the landscape is experienced in a dynamic manner. And indeed, I recall Mr Meredith making similar submissions. That is, that one experiences the landscape as one moves through the landscape, and that it's artificial to seek to quarantine different parts of it and assess them independently. And we don't take issue with that proposition, nor is it the way that we've sought to assess impact. We've sought to address these aspects both in submission and in evidence. And we readily accept that the extent of impact will differ depending on one's location and depending on one's activity. And in relation to the concept of cumulative impact on people journeying along or adjacent to the river, we repeat the submissions already made about the very limited extent of visibility from the river, and we rely upon the evidence that you've heard to the extent that the visibility will not materially alter the experience of people journeying along the river or those walking through the Lower Glenelg National Park. Then at paragraphs 231 and 232, we respond to the particular submissions made by Mr Turner concerning the visualisation at Simpson's Landing. I'm not going to read through that part of our written submission. We rely upon the explanation given by Mr Hark as to why the approach adopted to prepare that visualisation is an appropriate one, as to why it gives an appropriate approximation of what the visual impact would be from that location. Now, Mr Turner raised various other issues that we've responded to in writing, and we don't need to address further this afternoon. I'd like to pick up then again at PDF page 64, which is...
noting the time, Mr Chester, would it be an appropriate time to break?
Yes.
So we're at page 6. When we come back, we'll be at page 64.
Yes, that's a good idea.
Thank you. Back at 12:30.
Thank you. Well, we'll pick up for the final push, which is the part of the submission that addresses the other individual submissions. And at paragraph 238, we set out a list of those individual submitters that raised issues in respect of biodiversity impacts and or visual impacts, which again seem to me to be the key issues that were raised. And at 239, we make the observation that it's beyond the scope of these reply submissions to respond to all of the issues that were raised. But again, we recognise the committee will need to consider the issues that were raised and consider those issues objectively, having regard to the entirety of the materials before it. And I suppose just pausing there, objective really is the operative word, that the assessment that are called for under the legislative frameworks require an objective assessment of impact. And I've made a note to myself here to reference submitter number 211, which was Mr. Malseed Harris. And Mr. Malseed Harris really should be added to the list of submitters at 238. And I remember Mr. Malseed Harris's submission because it was Mr. Malseed Harris who used to have tea with my mum. He advised everybody. And he went on to make a submission to the effect that the impact of this project on the Glenelg River should be considered comparable to the impact of the Franklin Dam project in Tasmania. And it's a good illustration of why one need be objective in an assessment of this type, because I'll try and be polite, but it's an absurd comparison to seek to draw in my submission, that the damming of the Gordon River in Tasmania, which would have resulted in the flooding of the Franklin Basin and the very substantial environmental impact on the Franklin River, is so far removed from the nature of the impact of this project on the Glenelg River to be a very poor comparison indeed. And it's an example of why in my submission an analysis of this type need be one based upon evidence and need be one based upon an objective assessment of impact. Here, the impact of this project on the Glenelg River is very minor indeed in our submission. What we do for the balance of this part of the submission is respond to particular matters that were raised. I won't address all of them, but I will note that at paragraph 242, submitter 210, that is Mr. Meredith, and the submitter number 58, Jack, raised submissions in respect of the extent to which the project would compromise outdoor education programs run in the area. I know Mr. Meredith was online a moment ago. For what it's worth, over 30 years ago, I was the beneficiary of Mr. Meredith's outdoor education programs. He was very good at it. But in our submission, what emerges from the material before you is that, objectively speaking, there is no proper basis to contend that this project would compromise the locality as being one that is appropriately utilised for those purposes. Again, what is called for is an objective assessment, and when one has regard to the objective assessment of visual impacts or noise or any of the other applicable impacts that arise from a project of this type, one sees that there will be a degree of localised impact, but not to such an extent that would preclude programs of that type being successfully run within the locality. The next matter that I wish to address is at paragraph 247 at the bottom of the next page. Here we respond to submissions made by Mr. Stokes concerning the historical heritage overlays that he identified as applying in and around the subject site. Of course, it's the case that the committee must assess this project based on the controls that exist at the present point in time. For what it's worth, it seemed to me that a number of the historical overlay controls to which Mr Stokes was referring have in fact been translated into the ESO or SLO controls. But be that as it may, the committee must of course assess the project pursuant to the existing terms of the scheme, and that's what we've done in our assessment before you. And we note again, in respect of SLO1, the analysis contained within Technical Note 34 and within Document 336, and of course Mr Glossop's assessment of the project pursuant to the various planning controls, including ESO1. Before I move on from Mr Stokes, we do make the observation that Mr Stokes is one of the few submitters that at least we've ever encountered in a submission in a process like this who, having heard the evidence that has been given, indicated that his position changed in respect of the project. That is, Mr Stokes indicated that he was originally opposed to the project, but that subject to, or having heard the evidence from the various witnesses called by the proponent, his position changed. And we commend Mr Stokes for actively engaging in the process in that way. At paragraph 249, we note the various submissions that were advanced in respect of bushfire risk. Mr Lomas in particular appeared in an individual capacity, and of course it's the case that Mr Lomas's submissions can't be taken to have been made on behalf of the CFA, notwithstanding his volunteer status within that organisation. And of course it is the case that the submissions advanced by the CFA were not consistent with those advanced by Mr Lomas, or for that matter by Mr Biggs, Mr Rhodes or Ms Rhodes. And while we don't take issue with the proposition that these submitters have experience in managing and responding to fire risk within the local environment, including within the pine plantation environment, we did note that none of those submitters engaged with the evidence given by Mr Potter and by Mr Taylor in respect of the appropriate ways to respond to that risk, or indeed with the formal position advanced by the CFA in respect of the project. The next issue we wanted to highlight in our response is the submission made by Ms Thompson, as echoed by Ms Rhodes, in respect of what they contended was an absence of a social licence on the part of the proponent. And I must admit, I'm always somewhat confused by submissions to that effect. What we do say is that in this case, those contentions are unfounded. What the committee should properly recognise in our submission from the matters recorded within the EES and the way that my client has sought to conduct this hearing is that this is a proponent that has gone to some lengths to inform and engage with the local and regional communities in respect of the project. And of course, it's the case that certain members of the community oppose the project. We accept that, but that doesn't mean that there's a lack of social licence. And we note furthermore that this is not an instance where the committee could properly draw the inference that there is significant local community opposition to the project. It's always the case in processes like this that the majority of individual submitters that appear before the committee are submitters that oppose the project. But that wasn't universally the case, and we've made reference to various submitters who appeared before you in support of the project. But it's not just submissions made by people who are appearing before you that are relevant. There are a number of submissions, written submissions, that were actively supportive of the proposal. And so the proponent rejects a contention or any contention to the effect that somehow this project lacks social licence, or that there is a meaningful opposition. There's been evidence on the part of the local community to the project. As we move through the balance of the submission, we note that we have included a response to the submissions made by Ms Chalmers in respect of the consistency of the project to the Marine and Coastal Act. I won't work through those matters, but ask that the committee have regard to them in considering that issue. And I'll jump now to paragraph 255 on toward the bottom of page 70 of the submission. And here we see our response to submitters 156 and 157, that is Mr and Mrs Rhodes, who raised concerns in respect of the impact of the project on their property. And you'll recall, members of the committee, that one of the distinguishing features of this project that we've been seeking to identify is the relatively few, relatively little, low number of dwellings that exist in the vicinity of the project. And that was borne out in our submission by a number of submitters who sought to raise concerns about the particular impact of this project on their property. Mr and Mrs Rhodes were perhaps the exception. They were submitters who lived within 3.5 kilometres of the project. And what we wanted to identify in this part of our reply submission is how it is those matters were assessed in the relevant technical appendices to the EES. And what we have identified at subparagraph A is that in technical appendix L, the landscape and visual impact assessment, the property is assessed as having a low visual effect from the dwelling and a moderate to high effect from the driveway. And that's because the primary orientation of that dwelling is toward the coast and not toward the wind farm. Mr Hark gave particular evidence about this property, and that he gave evidence consistent with VCAT precedent that views from the driveway are not weighty or relevant consideration, and that he accordingly agreed with the low rating for the dwelling. So again, when one assesses impact objectively, one sees that the impact should not be considered anywhere near approaching a level of unacceptability having regard to the nature of this proposal. Similarly, we note in respect of technical appendix O, the noise and vibration impact assessment, that the noise levels predicted at the property were substantially in compliance with the applicable noise limits. The other submitter that raised particular concerns about the impact of the project on their property was submitter 104, Ms Kyler, and that submitter resides in Cashmore, which is a considerable distance from the facility. That is over 20 kilometres from the nearest turbine, and due to that distance, the property was not specifically assessed in either technical appendices L or O, and that in our submission suggests that the impact of that property should not be considered unacceptable. Now, what we then do in the submission, if we turn to PDF page 72, is address other matters. So we're moving away from matters that respond to submissions, and we're dealing with, in particular, the query raised by Member Kirsch in respect of the relevance of the panel report issued in respect of the Portland Wind Energy Project. And the long and the short of it, and we'll stick to the short of it for present purposes, is that in our submission, that report really should have no real bearing on the task before the committee. And the principal reasons why we say that is the case are set out at paragraph 260 of the written submission. Importantly, at that time, there were no policy provisions in the relevant schemes directed toward the assessment of wind farms, nor was there any general state guidance. And of course, that situation has changed drastically in the intervening 20 years. And much of the panel's commentary about the amendment, and indeed the general approach to assessment of that panel to wind farm proposals, has been overtaken such that it doesn't have material ongoing relevance. The second matter that we note is that that project was a project consisting of a number of parts, all of which the committee will no doubt be aware were situated in different parts of the coastline and contemplated turbines with materially different characteristics to the ones that are proposed here.
and indeed on land that itself possesses materially different characteristics to the land proposed here. And those differences are relevant in many respects, including particularly in respect of the impact of ecological, or the assessment of the ecological impacts having regard to issues concerning flight height and the like, and flight patterns. And so it's difficult and dangerous in our submission to seek to draw from the commentary in that panel report principles that materially or should materially bear upon this assessment, which of course must stand on its own. And so it's for those reasons that we say real caution should be taken to drawing concrete findings, if you like, from that report that might bear upon the appropriateness of what's proposed here. What we do go on to recognise, however, is that there are certain matters recorded within that report concerning the urgent need for transition and the particular suitability of land in and around Portland having regard to the wind resource that are relevant in the broad sense to the assessment that the committee must undertake. We've addressed you on those matters already. And we say that it was somewhat prescient on the part of that panel to recognise that the location of the plantations may themselves be locations that are appropriate for wind farms in the future. And what you see, for example, at paragraph 267 on PDF page 75 is firstly reference to that panel's recommendation or recognition of the strength of the wind resource in the region, and the reference to the 7 metres per second wind speeds, which is the average wind speed that we've referenced in respect of this project. And then secondly, recognition on the part of the panel that at that time, the height of turbines was inconsistent with their situation within plantations, and that what the panel recognised was that when these plantations mature, the panel would highlight the strategic opportunity offered for a reappraisal of land use future. There may be opportunities for wind energy development to occur on some of this land in preference to replanting. But of course, what we now know with the advancement of technology, and in particular the height at which these turbines can be constructed and delivered, is that there is no conflict of the type that the committee was identifying. Instead, what one sees is a very clear opportunity for synergies to exist between the two land uses, that is, plantation uses on the one hand and wind farm uses on the other. They are uses that are compatible in many important respects, important because they manifest in the various ways that we've sought to bring to the committee's attention in respect of reducing impacts, be it achieving separation from dwellings, be it locating, be it reducing the extent of native vegetation removal, be it locating turbines within areas of relatively low ecological value, relative that is to other areas in the vicinity. The panel was prescient in our submission to identify that land as potentially presenting appropriate opportunities for future developments, particularly having regard to the proximity of those locations to the existing infrastructure that exists within and around Portland. And that's why at paragraph 270 we say that that committee was correct to identify the particular attributes of the capacity for grid connection as being a relevant consideration. We, as we noted in opening, identified that amongst other factors as being points of distinction that distinguished this project from many other potential wind farm projects within Victoria, particularly as it concerned the capacity for this project to make a meaningful and timely contribution to the achievement of the various targets specified by state and federal governments in respect of greenhouse gas emissions and the transitioning of the electricity market. The The next part of the submission simply refers to the day 3 drafting that we've addressed you on earlier, and the final part of the submission is a high-level response or a high-level record, if you like, of the proponent's position in respect of the key issues that the committee need properly addressed pursuant to the terms of reference. And again, it seems to me that those propositions can be summarised into 4 high-level propositions that we identified in closing and that we again contend have withstood scrutiny through the submission process. The first is that the assessment documented within the EES and supplemented by the various materials before you is robust and substantial. The second is that the committee is in a position to assess the environmental effects of the project and respond to its terms of reference. The third is that, consistent with the bulk of evidence, indeed the entirety of evidence, and the submissions that you've heard, the committee should conclude that the environmental effects of this project are acceptable. And finally, that the mitigation measures proposed are robust and comprehensive and that they're given proper effect through the EMF and the incorporated document. And members of the committee, unless you have any further questions of us, that concludes our reply submission. We're grateful for the extra time that the committee provided to us and the opportunity to properly prepare responses to the matters that were raised in submissions. Yes, okay, and I'm advised that the one outstanding issue concerning the catchment management area as opposed to authority is simply an error and that it should be.
Thank you.
I did note that there's a number of inconsistent definitions for that authority, which I apologise for not picking up.
No, thank you.
Might be a correction to make.
Great, thank you very much.
Thank you.
There are no questions from the IAC, so that does bring us to the end of the hearing. And there's just a few things that I need to say in closing and explain the next steps for those who may choose to participate in providing comments on the final date project documents. So I'll note that after today, the parties will receive email correspondence from Planning Panels Victoria to confirm the post-hearing process and timeframes. And as noted this morning and just then, the parties will have an opportunity to comment on the final date documents by 12 noon Thursday, the 31st of July, with the proponent having an opportunity to respond to those 1 week later. I'd like to emphasise for parties, and I know we don't actually have many people here in the virtual room either, but there's no obligation for parties to take that opportunity. It's only if they wish to do so, and that comments will be taken by the IAC on a without prejudice basis, so notwithstanding that the parties' primary position on the project may differ from the information or the comments that they provide in on those final day documents. As noted at the beginning of the day, the ISC will consider, of course, all the submissions and written material before it, including the original submissions for parties who have not participated in our process, and that we won't accept any further material other than that which has been directed by the ISC. And while not anticipated, if the ISC finds that it's unclear on any critical issue during its analysis of the material, we may seek clarification or reconvene, but emphasise that we're not anticipating that will be needed. In line with our terms of reference, the ISC is required to provide our report to the Minister for Planning within 40 business days from the last day of our proceedings. So as directed, that's anticipated to be in the clock ticking in 2 weeks' time when the proponent's final reply comments are received. I will provide an opportunity for any questions, although as I note, there's not many people observing either, but there will be an opportunity for questions at the end. Before I do that, I'd just like to, on behalf of the IAC, so members Hirsch, Joyner and Wilkinson, I'd like to thank all parties and the proponent for your submissions and participation. I've like to acknowledge and thank all the community and individual submitters who've taken the time to participate and contribute, and of course to acknowledge and thank the proponents team for your assistance with many things throughout the hearing process, but hosting and recording the hearing, for example, managing the document sharing platform, and of course responding to the ISC's requests and questions throughout the process as well. I would like to thank the Planning Panels Victoria team for their assistance throughout the hearing process. I know they do a huge amount of work behind the scenes supporting not just the ISC, the proponent and parties. So a very big thank you to Ms Amy Salvarage, Georgia Broderick and Sarah Vojinovic and the broader team. So before we do finish for the day, are there any questions?
No, no, thank you very much.
Thank you. I'll just take a moment to check online, but I think that looking at we might be all good to finish. So thank you very much, everybody. We look forward to the next stage of our process, and thank you. And you're welcome to stay seated. Thank you.